Good morning. Due to COVID-19, Committee of Adjustment public hearings are being conducted virtually by electronic means through WebEx Webinar, an online digital platform, and streamed on the Toronto City Planning YouTube channel. Participants who have registered in advance will be able to make their presentations to the committee using WebEx Webinar, which is moderated by city staff. Anyone wishing to view the hearing may watch on YouTube. My name is Bruce Mullock. Panel members this morning are Larry Clay, Peter Reid, Joanne Hayes, and Yim Chan. Participants who have registered in advance will be connecting via computer, tablet, smartphone, or telephone. They have the option of participating via video or audio only. All participants will automatically be muted upon entry. When an item is called, each participant will be unmuted by the moderator, one person at a time. And we ask that you also mute your devices until you are called upon to speak. Those participating by video appearance will be temporarily upgraded to panelist status when their item is being heard. During this time as panelist, your camera will be enabled. You will only be visible during your 5 minutes allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Members of the public and applicants are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role should you fail to respect this instruction. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with Sections 45 and 53 of the Planning Act, 1990, as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, permission to extend or to alter lawful non-conforming uses, and consent to sever property in order to create new lots. Anyone in attendance today who wants to receive a copy of the decision of the committee on a particular application must submit a written request for a decision by email. Please ensure that you include your name, address, and an email address, because the Committee of Adjustment and TLAB, the Toronto Local Appeal Body, will be sending notifications and updates by email only. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body, or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government recently amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. As of November 28, 2022, only the applicant, the Minister of Municipal Affairs and Housing, and specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. Hearing procedure. I will call each item in the order that it is listed on the agenda. Where an application is uncontested, the agent or applicant may be requested to proceed with the presentation by the committee. When the committee does not require a presentation, applicants are advised or asked to advise the chair should they wish to speak to the committee. The committee may ask questions and or take the matter into committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee, and I will comment to you when you are approaching the 5-minute mark. When addressing the committee, please clearly state your name and address, and please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and may be asked to make a presentation to the committee. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application, if substantially revised, to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then individuals, either in support of or opposed to the application, will be invited to speak. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant or agent has the opportunity to rebut, but only those points and issues that were raised by the speakers. And that will mark the end of discussion. The application will then be taken into committee for a decision. Madam Deputy Secretary Treasurer, have the minutes of the last hearing been confirmed by members?
Good morning, Mr. Chair and panel members. For the December 7th, 2022 hearings, there are 2 sets of minutes, one from the morning session and one from the afternoon session, that are ready for adoption.
Thank you. Can we do those with one motion or should it be 2?
One motion is fine.
One motion. So I'll look to panel members for a motion to adopt those minutes from December 7. Ms. Hayes' motion. Is there a second? It is seconded by Ms. Chan. So moved and seconded to adopt both sets of minutes from December the 7th. All in favor, please, show of hands. And that motion is carried, unanimous vote. The minutes are adopted. Are there any declarations of interest by panel or staff on any items today? I don't see any others, but I do have one. I shall be recusing on item number 9. Number 8, HUMEWOOD. A family member of mine is acquainted with the owners. And in my stead, I appoint Joanne Hayes as acting chair for that item. Madam Deputy Secretary Treasurer, are there any requests for deferral?
Through you, Mr. Chair, I see none for this morning. However, there is item number 15, which is withdrawing.
Item 15 withdrawn. Thank you. So item number 15, panel, is withdrawn.
Through you, Mr. Chair, we'll need a motion on that.
I guess we can do that at this stage then.
Yeah.
Yeah, we can do it now. Okay, panel. So we're basically closing that file, are we, Madam Deputy?
Yes, we are.
Okay. So item number 15, panel. Looking for a motion, please, to close that file. Mr. Reed, thank you. Second to that, Ms. Hayes. Moved and seconded to close the file number 15. Those in favor? Show of hands, please. Unanimous vote carries the motion, and that item is closed. Thank you. And we move at this stage to our agenda for the morning. Starting with item number 1, 33 Sibley Avenue. On this item, the panel has before it the following materials. All those submitted by the applicant with the application. So, copy of plans of survey, site plans, floor plans, elevations. There's also a revised site plan from December 16. There are 4 photographs of the property, received 3 January, and there is an order to comply, which affects the property. In opposition, we have correspondence from 31 Sibley, 37, another from 37, and from 39. Sibley, all those in opposition to the application. And moderator, do we have the applicant with us?
Sorry, through you, Mr. Chair. Community Planning has submitted a very late memo, and I can have the presenter show that on the screen. And they're just requesting conditions. And that's presented right now.
Thank you very much. Okay, moderator, do we have the applicant with us?
We have both the agent and the owner with us. Colin, you've been unmuted.
And moderator, do we have one person in
yes.
opposition?
Yes, and the person in opposition as well. Sorry.
Very well. Good morning.
Yes, good morning, Mr. Chairman, members of the committee. My name is Colin Lightbourne. I'm the agent for the owner of this property. We do have 5 variances that we're requesting. Before I start my presentation, I'd just like to give a brief history of this property. Back in 2009, I submitted plans for a new house with a rear deck, basement walkout, and under the old East York zoning bylaws. Permits were issued in on September 29th for this house. So the deck is existing. The basement walkout is existing. So moving on, yes, there are 5 letters opposing this application from 23 Sibley, 31, 37, and 39. Now, I've had an opportunity to go through these letters. None of the neighbors have addressed the variances that we are asking. Most of their concerns were site view and privacy. Other unrelated issues like fire safety, electrical, etc., etc. The variances that we are seeking, variance 1, the canopy. This is, and of course, you're going to be treating it as a new structure. The canopies encroach into the side yard. Item 2, the deck, the rear deck is greater than 1.2 meters above the established grade by 0.2 meters. Building setbacks regarding the rear decks. Now, as I said, the rear deck was part of the old East York zoning bylaw. The new citywide bylaw came in, I believe, 2012. However, it is an existing condition, but this is going to be treated as a new structure. But based on the old East York zoning bylaw, we comply. Item number 4, the maximum permitted lot coverage is 35%, and we are asking a lot coverage of 49.15% above what is permitted. And then the rear, number 5, the minimum rear yard soft landscape of 50%. We're requesting 29, almost 30% coverage. Now, looking at the existing site conditions, at the back there is a covered garage currently. That covered garage or structure will be removed, thereby helping with the lot coverage, to bring the lot coverage down. I've done my part as much as possible to provide as much green space as I possibly can to bring it up to a reasonable level of 30% lot coverage. There is an existing garden shed, and based on my site plan, these are the areas that I'm proposing to provide the soft landscaping. Because of the length of the house and the setbacks from the rear wall to the back lot line, I cannot do any more than what I've given, shown on my site plan.
Mr. Lightbourne, Mr. Lightbourne, I'll ask you to make your closing remarks now, please.
Yes. So based on this, the variances that we are seeking are minor in nature, and they meet the 4 tests of the zoning bylaw and the official plan. So it is my understanding, as I said, they do meet the 4 tests, and I present this to the committee for their decision.
Thank you very much. Panel members, questions at this time. Ms. Hayes, go ahead, followed by Mr. Clay.
Thank you, Mr. Chair. Mr. Lightbourne, you're talking about revisions to the variances and reducing the lot coverage. And so are the variances stated in the notice what you're requesting, or are you making adjustments to those?
That's what I'm requesting. The initial rear yard with all hard surface. So the areas that I've known that I'm providing soft landscape are the shaded areas. So
okay, so but with the lot, you made some comments with respect to lot coverage and the removal of the aluminum covering over the parking area, and that was going to improve the lot coverage. With the removal of that, are you still asking for 49.15% lot coverage?
That's correct.
Okay, thank you.
Mr. Clay.
Thanks, Chair. I'm just looking at the site plan. I think I just need to understand this. The photos from one of the letters that we received in opposition showed the garden shed and the roof of the covered patio basically abutting each other. But your site plan appears to have soft landscape. Are you rebuilding your garden shed?
No, I can either leave the garden shed where it currently is on my site plan. I've shifted it over to the existing fence to provide more open space between the covered porch and the garden shed.
So, and we'll hear. Perhaps we'll hear from. Perhaps we'll hear from the individual who wrote that letter in, but it would appear that I guess are you turning it 90 degrees? Is that what your proposal is?
If you look at my photograph that I sent in, and just give me a second, let me go.
Is that it on the screen?
That garden shed, the front of the garden shed, looks like that's the shortest dimension of the garden shed. So the front on my photograph, that is 2.4 meters. It's the width of the garden shed.
Okay. All
So
right.
I'm not.
Okay, well, the chair, maybe if there's a speaker in opposition, if it's the one who took those photographs, maybe we can get an explanation from there as well.
We'll do that. Ms. Chan has a question first. Go ahead, Ms. Chan.
Oh, my question is to the applicant. You said that you're going to remove the roof of the parking space. Is that are you going to redo the floor so that you can install the soft landscaping and also keep some of the? Is it asphalt paving at the moment, or I just want to know what your plan is for?
I believe it is an asphalt parking space. So the shaded area is the proposal for soft landscaping in the form. It could be any form, garden or what have you. It doesn't necessarily have to be grass per se. He can put a garden there or a flower box as long as it meets the criteria of soft landscaping.
Okay. At this point, I just want to make a comment to those who may be watching at home for their information. This is a situation in which the proposal has already been built. So what the committee is actually being asked to do in this case is to legalize something which has already been built without the benefit of a permit. Again, for the information of those at home, the Committee of Adjustment in no way condones construction without permit. But sometimes applications do come before us, and so that people understand, our mandate in these situations is to look at these applications exactly as we do every other application. That is to judge them against the 4 tests of the Planning Act and to make a determination as to whether, had they not been built, whether they were still a proposal, if they were still a proposal on paper, whether we would see fit to approve them or refuse them. And that's how we'll be judging this application as well. But that's important background for people to have. Let's go now to the individual registered to speak in opposition and have them join us, please.
Shun Sai, you've been unmuted and you can turn on your video if you like. Shun Sai, you've been unmuted. Oh, there you are.
Good morning. Good morning.
We can see you, but we cannot hear you, so you may have to adjust your audio settings on your end, unfortunately. Mr. Sai, what we're going to do is we're just going to telephone you in. So you're going to be expecting a call from us right now.
Hello.
Good morning. You're with us now.
Good morning. Can everyone hear me okay? I'm so sorry for the technical difficulties.
Okay. Now we hear you just fine. You're with the committee. You have 5 minutes to address your comments to the panel. And as I say, we hear you fine. So go ahead, please.
Okay, great. Thank you, sir. So my name is Shantai, and I live at 37 Sibley, which is right next door to 33 Sibley. For everyone's information, there is no 35 Sibley. So I have sent in on January 3rd my letter of opposition, in addition to 4 other households that have sent in the letters of opposition. I would just obviously speak on my situation and why I'm opposing this proposal. So this morning, I would like to make several points, starting with the first one. So the owner of 33 Sibley has 5 zoning violations. I would just focus on number 4 and 5 as my first point. So regarding the minimum 50% soft landing space, the bylaw states it's minimum 50%, 66.81 square meters. Currently, it's at 29.95% or 40.02 square meters. Looking at the proposal drawing, it states that they are proposing 32.31% or 43.19 square meters. So that is a deficit of close to 18% or 23.62 square meters. Now the next item, a max lot coverage of 35%. The bylaw states that max 35% or 104.86 square meters. Currently, it's standing at 49.15% or 147.27 square meters. The drawing is proposing 47.639% or 147.73 square meters. So that is over by close to 13% or 43 square meters.
Can you tell us the impact that those figures are having? Tell us the impact.
Yes, of course, sir. So in my letter that I sent in, I've attached many photos of the impact. So when you're looking from my property, what I see is basically his house, which is attached to the deck, raised deck. Sorry, that's not my file. Mine is January 3rd opposition letter.
Just hang on for 1 second until we get.
Okay.
This yours? Okay.
Yes. So as you can see in the photo, you will see the house, the deck with the roof that's attached to the house, shed, and then you see the steel garage. So basically, what you see is almost one continuous structure from Sibley Avenue to the alleyway, and there's nowhere in the neighborhood or any other neighborhoods for that matter that has no open space or green space. Should I move on to my next point?
Carry on, please. We're listening.
Oh, okay. Yeah, thank you. So point number 2. So I have some serious doubts about the dimensions of the existing structures and spacing in the proposal drawing versus what is reality in the applicant's backyard. So for example, the space between the deck and shed is, I've measured 0.0787 meters apart. And this is evident in one of the photos in the file that we are looking at now. In the drawing, it states as 2.9047 meters. So that is a huge deficit for that. Second example, so the existing shed is listed as 3.66 meters in length by 2.438 meters width. So in another photo in my file, you will see that the width is 3.68 meters wide. So that's a difference of 1.25 meters.
Okay, Mr. Sai, I'm going to have to
Yes.
ask you, you're approaching your 5-minute mark. I'll ask you for your closing
Okay.
comments, please.
Okay, sure. Thank you. So my closing comments is that the construction without a permit has greatly impacted my family's quality of life. I've stated these points in my letter that everyone's looking at. But importantly, I think everyone should abide by the zoning bylaws that the city has set forth. As mentioned in my first point, the 35% minimum, the max 35% lot coverage and the minimum 50% soft
Mr.
landing.
Sai, your time is up. Your time is now up.
Okay.
Thank you very
Okay,
much.
thank you.
Thank you. Okay,
Thank you.
so at this point, we'll go back to the applicant, who will have a chance to rebut. And we ask the
Sorry,
applicant
Mr. Chair, I have a question of Mr. Sai.
I beg your pardon. Go ahead. Mr. Sai, hang on. We have a question for you.
So, Mr. Sai, if I'm understanding what the applicant indicated in his initial submissions, it appears based on their site plan that they're intending to rotate the shed to give a little bit of space between the deck and where the shed is and make that soft landscaping. And that's what I think what he verbally said is what their site plan seems to illustrate. Does that I know I'm catching you off guard here, but does that make any difference in your submissions with respect to impact?
Thank you for your question. No, that is an impact because, again, what we're looking at right now on the screen, that is the new proposal, and the new proposal is still grossly violating that 35% max lot coverage and the minimum 50% soft landscaping. He's still very short, even with what he's proposing.
Thank you.
Thank you.
Any further questions of Mr. Sai? Hearing none, let's return now to the applicant for rebuttal.
Yes. Mr. Sai stated that there are no other properties on the street similar to this where the house, the garage, and the garden shed are closely in proximity to the house. Directly across the street from 33 Sibley, there is a corner lot. They have a very small rear backyard, and then there is a double car parking space. And I bet their coverage, based on the size of the lot, there are gross deficiencies there. So what I'm proposing for this, now, let me make it clear that the lot coverage is created by the fact that there is a roof over the existing deck. That area then becomes part of the lot coverage equation. The garden shed becomes part of the lot coverage calculation. I have from the rear wall of the house to the rear lot line in the laneway, 17.59 meters. So there's very little I can work with within that and within those dimensions. He is permitted a 2-car parking space. I've done my best to enhance the open landscape. I cannot meet the 50% because of the short distance between the rear wall of the existing house and the lot line. I've done my best to bring it up as close as possible. I'm asking for 30%. The difference of 20% is minor in nature. He's complaining about quality of life affecting his family and what have you. I might point out that from the rear wall of number 33 to his rear wall is approximately 32 or 33 feet. So if he has any concerns with that, I would propose that my client put a privacy screen there to alleviate any of his concerns regarding privacy. Light and view, I can't do anything about that because this house is 15, almost 16 meters in depth. So that is an existing condition. It was approved under the old East York zoning bylaw. So this, once again, I state that what we are requesting is minor, and it meets the 4 tests outlined in the official plan and the city zoning bylaws.
Thank you very much. Okay. The panel may have questions for you. I see that Mr. Clay does. Go ahead, Mr. Clay.
I do. So you've mentioned that you received approval under the previous bylaw. Was that approval for the house without the deck and the covered deck, or did that include?
It was the house deck.
It was the house
and deck.
and deck, but
And
not
the deck.
but not the covered.
Not the roof. That's right. The covered roof came after the fact.
Okay, thank you.
Mr. Reed, please.
Thanks, Chair. To the applicant, I know my colleagues have raised this, but I'm still having a difficult time getting my head around the site plan. There's a substantial gap that you're showing between the existing porch and the garden shed. And I know that you spoke of moving the shed, but there's a very large tree that would be right in that spot. So can you just clarify what's happening with the garden shed and the spacing between it and the porch and the parking area?
Well, my intent was to open that area up between the porch and the garden shed. I do apologize. I overlooked that tree, but that garden shed currently is sitting right next to the tree as it is. I just rotated the garden shed, as I stated earlier, to give some distance, some light between the covered porch and the garden shed. Whatever area is required, I will still be seeking 30% open green space. That's what I would be providing.
Okay, my difficulty though is what you're showing in the site plan would result in the removal of that very significant tree, and I guess you have or urban forestry hasn't been informed of that, so I'm not sure where that puts us.
The tree will not be removed.
Okay, so the site plan is inaccurate then.
Well, yes.
Okay, thanks.
My question for you, Mr. Lightbourne, relates to the order to comply and to the rear deck and the rear deck cover. So the order to comply says that a rear deck has been constructed without benefit of a permit. So I'd like to hear your take on this. Was the order to comply issued when the roof was being constructed, or when the deck and the roof were being constructed? Was the deck itself? Was the deck itself?
The deck is existing.
I'd like to finish my question, please.
The deck was there before the roof.
And the deck was approved as part of the original application?
I believe, looking at my site plan, the deck was 10 feet.
No,
So
not my question.
it looked
No.
like-
My question is, was the deck part of the original application which received approval?
The original approval for the deck, based on my site plan, was 10 feet, or 3 meters.
Okay, you're not answering my question.
I am.
My question is, was the deck itself, not the cover, was the deck part of the original approval for the construction of the house?
The deck was part of the approval, but on my site plan, I showed a deck off the back wall, 10 feet.
So I think, Chair, the current deck exceeds 10 feet. Is that correct?
The current deck is a little more than 10 feet.
What is the dimension? What is the depth of the current deck?
4.572 meters.
So that's substantially more than 10 feet.
That's correct.
Thank you.
Thank you. Any further questions, panel? Ms. Chan, go ahead.
Yeah, I just want to make sure what we are looking at. There are two site plans. Is the revised site plan the one that we are on the screen, or you have another one in the package? We have another site plan which is got bubbles, revision bubbles of some. So
Well,
Good point, because there was a
what I
revised.
have-
I'd like to have let's put up the revised site plan from December 16, please.
December 16th.
Oh,
Yeah,
there-
I just want to
there
make
is
sure.
There is a site plan, and I have it, revision date December 15th.
This, you see, this is the one, it's not the one that was sold earlier. This one is the most updated one, right? With the revision bubbles on the left? Okay, I just want to know. So the other question is, I asked earlier, you said that you're going to, for the parking area, there's a sort of a roof. In the photographs, there's still a roof. Are you planning to remove that roof, and the parking space will be uncovered?
That roof has to come off. If that roof stays, then the lot coverage will be in the area of 92 to 95 times the lot area. So that roof has to come off.
Okay, thank you.
The
Yeah.
only roof is the roof over the current deck.
Thank you. Yeah.
Any further questions, panel? If none, let's take this one into committee for discussion and moving toward a motion. So we are now in committee on this application, moderator. And okay, Mr. Clay, go ahead.
Sure. Thanks, Chair. I'll start. I think I look at this in the context that had this application come before us as currently constructed without having been previously built, I think I'd have some difficulties with it. I am concerned about the lot coverage. I am concerned about the rear yard landscaping. I am concerned about I mean, I may not have had any difficulty if it just been a wooden deck of 10 feet. But this is almost 15 feet and it's covered and really does constitute an outdoor room. And I think, you know, the neighbor made a fairly compelling argument about the impact of this on him and other neighbors. And I just think that what they're asking for, again, even if this came to us, you know, and it hadn't been pre-constructed, I think I'd have some difficulty with it, given you know, the rear yard coverage and landscaping issues.
Thank you. Anyone else? Thoughts? Ms. Chan, then Mr. Reed.
Okay, yeah, I agree with Larry in some point, but also at the other point, I sort of think if this is actually a propose of a one-story addition at the back, right? So we consider it's an enclosed space. In that sense, the impact is more or less, it will be the same. But it's not asking for a variance for the building depth or length. So in that sense, I sort of have some kind of sympathy, because the applicant seems to have make a lot of effort to comply with bylaws. I'm willing to take off the roof of the parking space, and I think they're trying to mitigate what's there already. So in that sense, I think that if the impact will be there if they're going to build addition anyway. So I think that one story is not going to be, the impact is not going to be that large. And I'm willing to support it if we tied it to the revised site plan. And according to the site plan,
Okay,
I
thank
can
you.
support it.
Mr. Reed?
Thanks, Chair. I understand both of the comments from my colleagues. My challenge with the site plan is that it's not accurate, and I think that if we do tie it to the site plan, then that would require the removal of a very large tree. So I don't know if there's some way that we could incorporate that. I do think that the variances themselves are relatively minor, and I think the move to increase the soft landscape and improve the situation over what it is now, I think those do constitute real efforts. But I'm kind of trying to get my head around how to approve this with an inaccurate site plan.
Okay. Ms. Hayes, do you wish to comment at all? If you don't have to.
I agree with the comments of Mr. Clay. I think overall it's too much. I think the roof over the deck and the length of the structure already and the impacts on adjoining neighborhood, I think it reads like an addition to the house, and I can't support the application.
And I can't support it either. Almost based on the simple facts of the coverage deficiency and the soft landscaping deficiency.
Chair, before we proceed to a vote, I didn't quite catch early on what the planning conditions were for, or proposed planning conditions. Can someone just
You're talking about the late arriving.
Yeah, I didn't
get
get a chance.
I think it was screening and planting of a tree.
Okay. Okay, thank you.
Okay, then, is anyone ready to move to a motion? To make a motion?
Chair, I'm happy. I'll make a motion.
I think Ms. Hayes just beat you to it.
Oh, I'm sorry, Joanne. Go ahead.
Thanks. For all the reasons stated, I would like to move a motion to refuse the application.
Motion to refuse. Is there a second to that? It is seconded by Mr. Clay. So those in favor of the motion, please show of hands. Those opposed. And let the record show that Ms. Chan is in dissent. But with that, the Motion is carried and the application is thereby refused. And the panel moves on to item number 2. (101) Galley Avenue. Before us, the panel has material submitted by the applicant, a front elevation photograph, and we have opposition correspondence from 103 Galley, another 103 Galley, 118 Galley, 120 Galley, 110 Galley. And there is a 17-signature petition in opposition, signed by the owners or occupants of Galley Avenue and Pearson Avenue, received on January 3, 4, and 5. So, moderator, we have a number of people standing by on this application.
Yes, we have 4 of 5 speakers in opposition already registered, and I'm attempting to get the last one in as we speak.
Thank you very much. Okay. Let's have the agent join us then, please.
Morning, Mr. Chair.
Good morning to you. You have 5 minutes to present your application to the panel. Go
Yes,
ahead.
can we bring up the public notice first, please? I'd just like to make 2 small changes and just alert the committee of another change. We did submit a revised site plan on January 10th that is going to remove variance number 5 and variance number 6. That deals with, variances number 6 and number 7, not 5. Variance number 6 and number 7, which deal with rear yard landscaping, as well as the size of the ancillary garage. Those plans have been date stamped January 10th, and I would ask that any approval, if meritorious, be tied to that revised site plan. Additionally, if we could go up, please, in light of the recent OLT decision that came down on November 30th, the actual permitted height for the subject site is now 11 meters. I did speak with the zoning examiner, and he confirmed that that is not a required variance. However, out of an abundance of caution, I would still like to seek approval just in case. But again, the OLT decision added 1 meter in height to all R as well as RD districts in the City of Toronto, the old City of Toronto. Additionally, the maximum main wall height requirement or permitted would be 8.5 meters, not 7.5. That is more just for information before I start my presentation. Now, if we could go to the site plan.
Just a moment, please. So just to be clear what we're doing here, numbers 2 and 3 remain as they stand. That's how they were circulated. But you've chosen,
Correct.
We understand your comment, but you've chosen to remove number 6 and 7 from consideration, so they are deleted.
Correct, Mr. Chair.
Very good. Okay. So panel, just for your understanding, that's the situation. 6 and 7 are gone. Everything else stands as it looks, as it stands. Go ahead, applicant.
Yes, can we please go to the revised site plan I submitted? I just want to review a couple of the impacts related to the proposal and how that fits onto the adjacent neighbors. That's fine, actually. We can leave it here. It doesn't have to be the revised one because it really doesn't affect the adjacent neighbors. So the proposal for what we have is a 3rd-story addition on the front portion of the dwelling, a 3rd-story addition to the rear, and a further 2-story addition at the rear. What's important to note is where these additions are being appropriated and where that side main wall height is in relation to the adjacent dwellings. If we could zoom in on the property specifically where it says 3-story, yes, right there, please. So what we see here is that 3-story portion there is actually recessed considerably from the 2nd floor. So that proposed 2-story brick addition we have on the screen there is recessed 3.81 meters as we get to that 3rd story, which is the request for the main wall height. So that main wall height is appropriated essentially if we look at the adjacent dwellings, basically almost in line with each 1-story addition. Now, that speaks to the impact of this addition and where that main wall height is visible into the neighboring properties. And again, I'll go back to that when we deal with the elevations. 2 of the variances, in my opinion, are really tied together. One would be the first one, which is the front yard setback. This is as a result of enclosing that front porch. And if we just zoom up a little bit to look at the porch, we can see that the proposed porch is built in line with both the adjacent dwellings at 99 as well as 103. Additionally, if we look at number 99, they also have an enclosed front porch. This is not the introduction of a built form that is not common along Galley and is not present in the broader neighborhood itself. So the request for the front yard setback is because that is proposed to be enclosed. That is directly tied to the building depth that is being requested. The dwelling itself is a hard 17 meters in length. There is no livable space outside of the enclosed porch that goes beyond 17 meters in depth. If we could bring up one of the side elevation, please. So speaking to the impact and how that relates to the adjacent neighbors, just one of the sides, please. Yes, if we could zoom in there, mainly at the rear. So the impact of how this is felt in the rear yard, as we see here, that main wall height is appropriated in the middle of the dwelling. And as we saw on that site plan, essentially in line with the one-story additions of both the east as well as the west neighbor. Additionally, that main wall height, as it addresses the rear of the property where the privacy screening is 7.41 meters in height. So as somebody would be in their rear yard, it is actually below the zoning bylaw requirement for a main wall height, and any impact is mitigated by that. We have also added the privacy screening around the deck, which again, in the R district, is a permitted deck. It is not regulated by the 4 square meters, as the R district is the most permissive of all of the zoning categories. To deal with the FSI, that's directly raised to the impact.
Just, you've reached your 5-minute mark. I'm going to allow you 1 minute extra time because of the discussion we had to have about deletion of those minor variances. So please go ahead. You have another minute.
Perfect. Just in terms of the impact of the FSI, really the intent and purpose of the FSI provision is really to ensure that buildings are compatible in terms of massing as well as scale. We know from the increase of the OLT decision permitting the 11 meters in height, this is what the zoning bylaw envisions in terms of a massing as it faces Galley Avenue. And again, it is mitigated, the impact, by that recessed third floor, not extending all into the rear wall of the proposed addition. And I'd be happy to answer any questions the committee may have.
Thank you very much. Panel members, do we have questions at this stage? No. Okay. Let's go ahead and hear from the group of registered speakers standing by. Moderator?
Catherine Daub, you've been unmuted.
Hi, my name is, can you hear me?
We do hear you well, Catherine. Good morning.
Great. Hi, good morning to you. My name's Catherine Daub. I'm the owner of 106 Galley, which is almost right across the street from the applicant's address. My first point is this application is anything but minor. They are looking to more than double the allowed legal square footage on this lot. And this is a small downtown lot. We are not talking, you can see the measurements. This is too much on too small a lot. As simple as that. I understand and hear the applicant's arguments about how it would impact the neighbors. I'd like to disagree. I'd like to say just the sheer mass, bulk, and height of this thing is going to change the openness, spacing, and streetscape of our street, which is a street full of 100-year-old houses that are somewhat uniform, which that's not a thing, but there's a reason people enjoy the neighborhood, and part of it is because of what the streetscape looks like. I think it's going to create enormous light and privacy issues for the neighbors due to the proposed height and things like the back deck. And I think it begs the question of necessity. This is already one of the largest homes on the street. Numerous neighbors have successfully renovated the same footprint into beautiful 5-bedroom homes with finished basements, with nanny suites. This is not a lot that can take a monster home. And I think the number number of people you have opposing this application speaks to that. And this is not a minor variance. More than doubling the square footage is not a minor variance. And that's it. Thanks.
Thank you very much. Let's see if anyone on the panel has a question for you. Panel members? No. Thank you, Catherine. Moderator, next speaker, please.
Through you, Mr. Chair, I've tried reaching to Maria Davis numerous times and they have not responded. So the next registered speaker in opposition would be Judy Robertson, who has been unmuted.
Good morning.
Hi, and good morning. This is Judy Robertson. You can hear me okay?
Very, very clearly, Judy. Go ahead.
Oh, thank you. I live at 103 Galley, and I guess I agree with what Catherine just said. I was very surprised by the sheer size of the addition. It's a single family house, and it's a lot of a house for the size of the lot. And I also agree that it's not a minor ask. It's a major change. I'm also concerned if this proposal goes through and it's built, it sets a precedent, which means anyone else in the neighborhood can build of equal size. And excuse me, and my worry is, what if our neighbors on the other side of us decide to build something just as big? Then we are going to feel very walled in. And I'm also concerned about the lack of sunlight coming into our backyard. Yeah, that's my husband, Michael, will speak more in regards to other concerns that we have.
Thank you very much. Questions? No. Moderator, next speaker, please. Thank you very much.
Thank you.
Yep, the next speaker is Paul Best, who has been unmuted.
Hello, this is Paul Best.
Good morning.
I'm sorry?
Good morning. Go ahead, Paul.
Good morning. It's Paul Best. I live at 118 Galley, opposite side of the street. The proposal is of such a nature and such a size that I worry about the precedent it would set, if approved, for the whole neighborhood. I know from having other houses, many houses on the street have gone through renovations and additions. Usually, the additions are single-story, quite minor. Our own house, for example, before we moved in, had a ground floor extension that's it's 10 feet by 10, and others are of a similar nature. If this is approved, we could see all sorts of houses following this precedent that would totally destroy the nature of the whole neighborhood. That's it.
Well, thank you, Paul. Panel members, questions here? Hearing none, let's go to the next speaker, please.
The next speaker is Michael Cruz, who's been unmuted.
Yes, good morning. Can you hear me?
Yes, we hear you, Michael. Go ahead.
Yes, good morning. Good morning, members of the committee. My name is Michael Cruz. I live at 103 Galley Avenue with my wife, Judy Robertson, and our 14-year-old son, Roman. I believe our letter and illustrations on file demonstrate the sizable impact of variances at 101 Galley possess. I want to speak to and reiterate the imposing physical presence the numbers in this application will have on our daily lives and the enjoyment of our property. The excessive height, the sidewall, for 72% of its proposed length will be 2.71 meters, that's 9 feet above the allowable, which will be 0.9 meters, that's 3 feet above the existing ridge. The dominating mass, the two-story of the two rear additions, will extend for 50% of our backyard. And that being just 0.46 meters, that's 18 inches away from our property line. And with the rear deck that extends, with the rear deck, that the build will extend about 70%, out into a backyard. This built form will cut off around 50% of our view to the east, block our access to that part of the sky permanently, and cast a significant shadow on our backyard. I want to make a response to the agent's comment that a three-story addition next to our one-story addition is really quite mitigated. If you look at the drawings, it's very clear that that three-story portion of the proposed addition completely dwarfs our one-story addition. And even if we are on the other side of that, we will certainly be having full view of that addition and having that impact our line of sight and openness and so on.
Okay, just a second. Here's a photograph that you submitted. So
yes.
If you could just explain through this photograph what that impact that you're describing is.
Well, the red line is the line where the second or the extent of the two additions would come to. So you can see how much it blocks the addition, our view to the east. If you look at the posts that are there, the 2x4 posts have been put up during this construction. That's 8 foot high. It's an 8 foot 2x4. That addition, the three-story, will be like over about 4.5 times that height of that 2x4. The two-story, I don't know, it's going to be around 4 times the height of that 2x4. So in our minds, it's a very imposing built form. I would like to continue with my statement, if I could, please, or unless you have questions.
No, go ahead. That helps. Go ahead.
Okay. As we've illustrated, the height and mass of the proposed build is misrepresented on the drawings relative to the existing house. This has significant bearing on the perception and the impact of the variances being sought. If people felt that if it was within the existing height of the existing house, it seems reasonable. But in fact, the ridge of the proposed house is 4 feet above the current ridge. Moving on. We keep asking ourselves, why so big? In reviewing and discussing this application with our neighbors, their first comment is, why so big? Followed by, it seems like a lot of house for that lot, and our backyards are small as it is. We have 17 signatures from 14 houses that share these thoughts, and that's with many neighbors being away for the holidays. 101 Galley will be a 4.5 bath, 4 bedroom, plus office, plus sitting room, single family dwelling that will be 50% over the permitted space floor index. Ironically, our home next door at 103 Galley is a 4.5 bath, 4 bedroom, plus office, plus sitting room, single family dwelling, but it's comfortably nestled within its existing built form. I believe this application is not about urban densification. It's about imposing an oversized single-family house onto the fabric of our neighborhood. We understand the official plan, the Planning Act, and the city's bylaws are written to ensure a variety of housing choices, but while respecting and reinforcing the character of neighborhoods. In that spirit, we ask that a more reasonable and appropriate development be proposed for this property. One minor, it's not so minor point. The owners have not reached out to us throughout this entire process.
I'll ask your final comment now, please.
And that's really my final comment. It would have been nice to, have been approached by them and have the opportunity to discuss it with them for us to be able to
Your time is
bring
up.
up our concerns prior to this hearing.
Okay,
Thank you.
your time is up. Panel members, questions of this speaker? Hearing none, let us then go back to the applicant, who will have a chance to rebut, but only to the matters that were raised by the various speakers. Applicant?
Yes, I have a couple of points just to address. Precedent was mentioned a couple of times. As a planner, I don't really look at precedent in that important of a manner because every application does need to be judged on the merits and how that impact affects those adjacent neighbors and the streetscape as a whole. As I started in my opening remarks, we know that the permitted height now here is actually 11 meters. So that permitted massing from GALLEY is what the zoning bylaw envisions as per that OLT order. We also know that that OLT order has added 1 meter of side main wall height that corresponds with the extra meter in the overall height in the R and RD zones. So when we go back to that idea of how that FSI is appropriated on the site and how that impacts the adjacent neighbors, we go back to that rear portion being recessed and the dwelling, in fact, being 17 meters in length of livable space. This R zone itself actually doesn't regulate building length. It regulates only building depth. The difference between length and depth is one is measured as the actual house itself, whereas depth is measured from the required front yard setback, which is the adjacent portion of the two lots. So in terms of the length itself and how that's appropriated, we are essentially 17 meters of livable space front to back, with that third floor being recessed 3.81 meters or 12 feet 6 from the rear wall, and that portion there having a height of 7.41 meters as it relates to the rear, to that rear two-story addition. Yes, this is a dense urban area. Yes, this is a rear addition, but again, it has been appropriated in a manner to take into account that rear area of the adjacent dwellings and how that zoning bylaw starts to envision rear additions within the neighborhood itself. In terms of privacy and overlook, very simply, there are no side windows proposed on either side of the east or west additions. The privacy screening proposed on the third floor is proposed already to be along the east, west, as well as south portions that face the rear yards. And I'd be happy to answer any questions that you might have.
Panel members, we'll go first with Ms. Chan, followed by Mr. Clay, then Ms. Hayes.
Yes, I only have one question. It's about the FSI. You have said that is appropriate increase. Do you have examples of other recent developments that will be able to compare to yours?
Mr. Chair, Ms. Chan, it's very hard to calculate FSI. Really, the only ability we have is through past decisions. In terms of really passing the eye test, it's very difficult because, as we know, numerous different ways FSI can be hidden in roofs, in attics. So I don't, Mrs. Chan, but what I would say is the impact of that FSI, in my opinion, is mitigated as to where it's been appropriated as it relates to those adjacent dwellings. And I think that's the intent of recessing that third floor. And that's really where we're looking to have that increase.
Okay, thank you.
Followed by Mr. Clay now. Go ahead.
Just related to that, I should have asked this earlier, but do you know what the current FSI is of the existing building?
Yes, I do. We can see it on the screen there through you, Mr. Chair. Mr. Clay, it's 135.68 square meters.
No. What's the percentage, the FSI?
Bear with me. I can calculate that. 0.46.
You're at 0.46?
Correct.
And you're going to
1.1.
1.1. The other question I have, did you or your client try to reach out to the surrounding neighbors to have discussions on your proposal?
From what I understood, the clients did speak with one of the adjacent neighbors. I'm not sure what the outcome of that was, but I know they did speak with them. I believe there is work undergoing at the property right now. There is some construction taking place.
Okay, Ms. Hayes.
Thank you. So, in terms of the sidewalls, I've heard your submissions with respect to the recent OLT decision. What do you have any examples of sidewall heights that you're requesting? For example, what is the height of the dormer on the neighboring property from a sidewall perspective?
Well, it would be similar to where that second story top roof is now at that 7.41 meters that we're just extending that second floor to the rear.
Okay, so but you're still asking for, although, you know, from 8.5 to 10.21. So do you have any, can you point us to anything where that is representative of the built form in the neighborhood?
Well, I think I mean, I'll look right now to give you specific addresses, but to really examine, in my opinion, the intent and purpose of that kind of side main wall height provision is really where that impacts two things. One is to the rear, because we know from the front the massing is permitted at 11 meters. So when we look at that side main wall height and where that goes into the rear yards, it's really hard to see from the front what that extension is at the rear. So my opinion as a planner is that real intent of that side main wall height provision is to limit that impact as it starts to come away from the streetscape, especially in such a tightly packed urban neighborhood like this, where the dwellings are so close. They almost read as if it's a row of houses just because of the proximity or the reduced side yards. So I don't have an example because it's tough to get into those rear yards. But to go back to where that side main wall height is appropriated, in terms of that increase, is for that 3-story addition that doesn't extend all the way to the rear.
So are there any other examples on that street or in the immediate context that are full 3 stories?
There are 3-story dwellings on the street, absolutely, all over the street.
Okay, so I'm going to go back to the FSI. You know, you're looking to more than double the square footage of the existing home. So I'd like to understand or have some more specific submissions with respect to the FSI request, please.
Sure. Again, to go back to that intent and purpose of the FSI is really to create a streetscape and a volume and a massing that is as per that zoning bylaw and how it fits and how it relates to things like building height, side yard setbacks, building length, building depth. What are we creating? What are we adding that's causing these variances? In this case, the only built form request that's leading to this FSI increase is essentially that side main wall height, again, that is recessed and has been appropriated away from that 2-story rear addition. So what's creating this increase in FSI is not side yard setbacks, because we are built in line with the existing dwelling, is not an increase in building length or depth for livable space. Frankly, not really an increase of the actual mass of the dwelling due to the recent OLT decision, but it is that side main wall height that is creating this FSI increase. If we look at the balloon or the envelope through the zoning bylaw that governs massing and FSI.
Thank you.
Okay, any further questions of this applicant? Hearing none, it's time to, I think we can now take this application into committee for discussion, moving to a motion. So we can move to motion right away, or unless someone would like to make comments in advance of that. Any thoughts? Mr. Reed, go ahead, please.
Sure. Thanks, Chair. I'll start off. I think that altogether this does feel like too much. It feels like an overdevelopment of the site for me. The variances themselves, the one that really stands out is the FSI, and the way that additional density has been kind of taken on this site is to a big boxy piece on the back, and I think it extends further than anything else on that side of the block, and does change the character of those backyards that are adjacent to it. particularly because it extends out at the full width of the house without stepping in, even though it does step down from the third to the second floor. So for me, it's the impact of the variances are major, so I can't support this.
Thank you. Anyone else wish to speak? I'll just say that I agree with Mr. Reed's comments. I think that the backyard protrusion really will impact neighbors in a negative way, and that's the reason I can't support it.
So I'm happy to move a motion to refuse the application for the reasons I just discussed.
Thank you. Is there a second to that motion? It is seconded by Ms. Hayes. Moved and seconded to refuse. Those in favor, please show of hands. Thank you. Those opposed? And let the record show that Ms. Chan is in dissent, but the motion is carried and the application, therefore, is refused.
Through you, Mr. Chair, as amended.
The application as amended, minus items number 6 and number 7. Thank you. Okay, with that, panel moves on to number 3. 360 Winona Drive. Here before us are materials submitted with the application, and there is correspondence. In support, there are 4 form letters from owners or occupants of 354, 356, 364, 366 Winona. In opposition, there's correspondence from 358 Winona. So let's have the agent for the application join us, please.
Good morning, Mr. Chair.
Good morning. You have 5 minutes to address your comments to the committee. Go ahead, please.
Yep, thank you. Good morning, Mr. Chair and members of the committee. My name is Enrique Valencia, Valencia Enterprises, Inc. I'm the agent for the homeowners of 360 Winona, Marty and Ingrid. Marty and Ingrid, this proposal, they both intend to use this home for the next generation, which is for Marty to continue living happily with his son and his wife, Gabriela. I'd like to start with the statement for the owner's sake that we feel that we have done our due diligence to the best of our abilities. Both Marty and Ingrid are very welcoming characters in the neighborhood and have gone around to speak with their neighbors within a reasonable time frame, including both 358 Winona and 362 Winona, which are the adjacent neighbors. I'll address the concerns regarding the project at the end. For now, I just want to start with the variances. So 3 out of the 4 variances which are being requested are tied together, in my opinion, as they involve the existing footprint of the original building. Variance 1, 3, and 4, the proposal is simply to extend all the exterior original walls up 1 story, as they have the adequate structural support. Variance 2 involves the new platform, which is going over the existing porch. I don't believe this is a major change within the neighborhood, as you can find from balconies along Winona, a second story from balconies along Winona, and they're mostly commonly seen within the Toronto core, the downtown core at least. I do understand the concerns from the neighbor at 358 Winona, so my following remarks are to address her concerns. And if you can pull up her letter of objection, just so everybody could see the point that I'm talking about. Just the first page. Yeah, thank you. In terms of item 1 in her objection letter, the survey plan used was the one for our property located at 360 Winona, which was used to apply for this application, and it's originally signed by an OLS. So all my documents are based off this document. Based on the conversations with my client, I understand there could be some confusion interpreting the site survey plan without a surveyor or architect present. The images presented in the objection letter don't show the dimensions, and realistically what we're talking about is about 17 to 21 inches. that space in between. Regardless, we don't intend to change this area. Our intention is simply just to go up one story, similar to what the neighbor already did a few years ago. In regards to item 2, the reason for the roof angle is to avoid unnecessary underpinning and higher construction costs. A geotechnical has already been brought in for a feasibility and soil bearing test, and meetings between the engineer, architects, and this report. This design is the one that was found to be most feasible. As it stands, 358 Winona sits south of 360 Winona, with 358 Winona already acting as a weather stop due to its current height. So if there's any snow, any rain, it's going to hit that wall and just go straight down. Most of the weather conditions tend to move from, I would say, southwest to northeast. It tends to change throughout the seasons. However, I don't think neither the neighbor or myself can really be accurate on that and how water is going to affect the property at that point. One thing's for sure though, standard stormwater management practices will be implemented, and we can take special precautions to avoid unnecessary accumulation of water in this area, which I don't think it was taken into consideration when they did their second story addition. But regardless, I hope this addresses all the concerns and the committee members can see that the application is minor in nature. Thank you.
Thank you very much. Panel, we have 2 speakers standing by. Shall we go ahead to them? Let's do that, okay. First speaker, moderator.
Edward Silvula, you've been unmuted.
Yes.
Good morning.
Hello?
Hello, good morning.
Hi.
Edward,
Yeah, yeah, sorry.
Go ahead. You have 5 minutes to address your concerns. Go ahead.
Just regarding how they're going to build a wall, and then there's only like maybe give or take from space to house, just like about 12 inches. How they're going to build a wall up? They're going to come on the property, which I don't want. And like, where are they going to put all their garbage? Where's all these construction trucks going to park? And there's no parking along these streets at all. It's really hard to find. So like, there's about 12 inches gap, and they're basically connected so close together. So how are they going to build this wall and do all this?
Well, Edward, we can put that question to the applicant when it's his time to respond. But
okay.
But what you are addressing there are construction issues, which are serious and they're real, but they are outside the authority of the Committee of Adjustment. We're here to deal with the variances proposed. So I want to ask you: do you have concerns about the actual impact on your property? I think are you next door? You're next door, right?
Yes.
Okay.
Yes.
So you are next door. So what are the impacts of the variances on you and your property and your enjoyment of same?
Well, it's going to be high up, and the concern is between the two houses. Like if it starts raining, it could cause like a problem. I don't know really, because I'm not an engineer. But like if we solve that problem, but I don't want nobody coming on our property putting scaffolds or anything like that at all.
Okay, so we can go back to the we can go back now to the applicant, and if there's anything else you want to add, do so now. Otherwise, we'll go back to the applicant and see. Do we have one more speaker standing by? We do. Okay. Okay.
Sorry.
Anything to add, Edward? Go ahead if you want to.
No, that's it for now. Thank you.
Thank you. And we do have another speaker standing by, so let's hear from that speaker.
Mako, you've been unmuted.
Okay, thank you. My name is Mako Bay. I'm a resident, owner of 358 Winona Drive. and I'm the opposition of this application because of the two critical reasons. Even though the applicant explained that there wouldn't be any problem, they concerned all my concern to the application. However, the between our house physically as well, it's very, very tight. I submitted 3 photographs of how it's like, so you can see it. And then also that slope of the roof, definitely it's gonna be eventually a problem for our property because it's older house, both of us. And my house is built lower. This is Winona Drive is slope from north to south, a south lower, and I'm south of applicant property. And any severe rainfall or any snow, whatever, at this point, we don't have any problem because their roof is 1 story. And, any water thing coming in between our property is just a result that we don't have any problem at this point. I have done waterproofing on our property, everything, but this Winona Drive tend to have a lot of water problem for the neighborhood if you don't do proper application to your basement or ground. And I'm really concerned about the roof, the slope coming directly to our property in a very, very tight space. And I'm not opposing for them to build second story, but to do more agreeable way for neighbors that, especially for me, the roof is sloping down to the south, all the way to my house. And that is very concerned for me. And if they can make a flat roof or just the roof slope goes to the west side. No, I know design-wise it may not be favorable for the owner, but any better solution if they can do, I can reconsider my opposition. So that's it for me.
Well, thank you very much.
Mhm.
Any questions, panel, for this speaker? Okay, so we've now heard from all those who are registered to speak. Let's go back to the applicant who will have a chance to comment on what's been submitted by the 2 speakers. Applicant?
Hi, so just to address Edward's concerns, in terms of not going onto your property, we can definitely try our best and make some kind of agreement. I know that you know the type of person Ingrid is. She's not looking to cause any issues or to argue with anybody. She just wants what's fair. The contractor hasn't been chosen yet, but there are construction practices like pre-built panels that can be built inside the home and then be anchored onto the existing house from our side of the property. So that's one solution that we can offer. The other, in terms of the garbage, really, if the bin is going anywhere, it's either they're getting a street permit to put the bin right on Winona, or they're putting it on their own driveway, which they're completely allowed to do as well. Ingrid has even requested that I recommend some type of contractor that is more environmentally friendly, which it's a new request for me, but I am looking. So that's all I can really say to address that. And in terms of Mako, her concerns, right now I'm just following what the engineer and the architects have submitted. Right now, this based off all those conversations, this is the best design that we found. Thankfully, now I know that you do have waterproofing on your side of the property, which I know for a fact our side doesn't. And that's why Ingrid's been dealing with this, and that's why this construction tends to tackle those issues as well. So we're not only just giving her a second story addition so that the family can move in, but we're also upgrading the house as well. Thank you.
Well, thank you very much. Okay, committee, your chance to put questions to the agent, please. Okay, I'm not hearing any questions. Okay. So I just had one question for you, agent, and that was with respect to minor variance number 4. And is that also an existing condition?
So the front wall, the very front wall, it is going forward about 2 feet, just to give it some character. But yeah, it was a request. Otherwise, the front porch would be quite big in that sense. And that was a back and forth we had with zoning as well. So that change actually came afterwards, after our first submission to zoning for the zoning application.
Okay, so it's not an existing condition. Is that
That one, no.
You're not sure whether it is or not?
Sorry, so no, that the required minimum front yard setback for the second story wall, that's not an existing condition.
Okay, thank you. And will that front yard setback cause the house to jut out a couple of feet in front of the houses on either side?
Exactly 2 feet.
Okay.
It's a 2-foot cantilever.
Thank you very much. Okay.
You're welcome.
Okay, if there are no other questions, then we can take this application into committee for a motion, unless anyone has comments first. Panel members, we're in committee now. Mr. Reed.
Thanks, Chair. I think what's being proposed is reasonable. The majority of the variances being requested are based on existing conditions, and this is really just a top-up. I understand the concerns about the angle of the roof and the water by the neighbor, but I think that's something we just have to have faith that the building department will opine on and construction practices will manage. So I do believe the variances requested are minor and move approval of the application.
Thank you very much. That is seconded by Ms. Chan. So it is moved and seconded to approve. Those in favor, please, show of hands. And that vote is unanimous. To carry the motion, the application is so approved. Thank you. We move on to number 4. Application number 4, 494, 496, and 498, Gilbert Avenue. On this application, committee has before it materials submitted, cover letter from the agent September 6, arborist report September 9, transportation and parking study by Mark Crawford, by CGH Transportation September 6. There is email correspondence, and that is from City Planning, January 4, and from Transportation Engineering, January, Transportation Services, December the 28th. So let's have the applicant join us, please.
Good morning. This is Alan Gaderi from Penalta Group.
Good morning, Alan.
I would
Alan,
like to
just hang on a second. I'm going to ask the panel, in that we have no registered speakers in opposition, I'm going to ask the panel if they require a presentation or whether they might prefer to put questions to you directly. Panel, any questions for the applicant? Ms. Chan, go ahead.
Oh, yeah, just a quick one. This barrier-free space, is it a visitor space or is for the or for the tenants?
It's a public space. It's a barrier-free parking stall for public, yes, public use.
That's what I want to. And then you used to need three. The three that used to be also, all of them are public spaces. Yeah.
That's correct.
Okay. Yeah. Thank you. Yeah.
Okay, I'm not hearing any further questions. So I think we can take the application into committee for a motion. Mr. Clay, go ahead, please.
Yeah, sure. I think this is a very straightforward application, Chair. I did kind of look through the transportation study. It was fairly comprehensive, and I think it supports the application. I don't think there'll be any negative impact on the surrounding neighborhood and residents. So I will move approval with no conditions.
Thank you. That is seconded by Ms. Chan. It is moved and seconded to approve. Those in favor, please show of hands. And there is a unanimous vote. It carries the motion. The application is approved. Item number 5 is 499 Main Street. We have application materials before us. There is a revised dimensions and materials plan from January the 9th. We have comment and correspondence from Urban Forestry, from TRCA. We have staff reports from Transportation Services, from Community Planning, and from Urban Forestry, dated January 4. There is correspondence in support from 532 Main Street. Moderator, let's have the applicant join us, please.
Lauren, you are in the meeting. You've been unmuted.
Thank you. Good morning.
Good morning.
Yes, so I've been a homeowner in the neighborhood for 8 years, street parking all this time. I've only recently determined that a parking pad in the front would be helpful. The street parking, there is limitations to how many cars can be there. Makes it very difficult to street park in the winter because of snow clearing. We've had 2 cars in our family hit on the street in the past year. Mine was a hit and run on October 29th and written off. I would really like to put in the smallest parking space available so that I can move to an EV vehicle. And trying to comply with all the bylaws that have been provided. In reviewing all the information that's been given to me, it sounds like I'm not sure what will get this approved because it sounds like it has to be 100% landscaping, which means no pavers whatsoever, even if they are permeable and, recognizing the need for appropriate water drainage. So,
Lauren? I'm
yes.
going to stop you there, Lauren, and just see if the panel members have questions for you. So, but the one I wanted to ask you was the current provision for parking. Is there any parking on your actual lot at the moment? What is the provision for parking for your property at the moment? Is it just street parking?
Street parking, yes.
Okay. Any other questions, panel? Okay, we'll go with Ms. Hayes first, Ms. Chan second.
So yesterday we were supplied with a new front yard layout. Is that an attempt to address the concerns of forestry and the repositioning of the tree? And did you have discussions with them, and does that resolve their concern?
The only thing that was updated was they wanted detailed lines or information added to it, but the actual drawing didn't change. If there's anything that I can do that would get it approved, I will. The tree moving it, that was already on original plans.
Thank you. Do you have any also, both planning and transportation have recommended that we refuse it. What are your responses to those comments?
The transportation one, sorry, let me just pull up my notes. The transportation ones I think was about the front yard landscaping, about how much has to be covered, limiting hard surfaces, and I don't know what would be required in order to get that passed. If there's certain types of materials that would make that approved. With the urban forestry one, this is a tree that I did have put on the property just a few years ago, so it's unfortunate that I do want to move it, but in order to accommodate a vehicle and a driveway, I would need to.
Ms. Chan, go ahead.
Oh, it's a similar question as actually I have mentioned. The community planning report is also recommend refusal. I just like to know whether you have addressed that or can you make comment on that?
I did. I messaged them back to say, if it's refused, what is it that they want to see? What is it that I can do in order to get it approved? And I haven't heard back.
Oh, I don't think they offer another alternative.
Yeah, so it sounds like just by where my house is located, the bylaw is going to say no because it needs 100% landscaping. So it sounds like it doesn't matter what I propose, it's just going to be a no. Is that how you interpret this?
Well, that's
yes, that's my question. Although it's very clear what their stance is, but then I thought that whether you have a second thought about proposing parking in the front. Yeah.
That I don't have any other recommendations or thoughts on it at the moment, but that's what I've been going over about for the last 6 months as I've been trying to get to this point, to just say, what is it that you would recommend? What is it that I need to do? What do you need to see from me in order to get past this bylaw?
Okay, well, just on that, just by way of a thought, the electric vehicles are good, but soft landscaping is a big concern too. And the reason that soft landscaping is embedded in the bylaw is because of the concern the city has for stormwater management. So the trend in the city has been to constantly decrease the amount of soft landscaping in favor of hard landscaping. And City Council hasn't actually really clarified this issue yet in the case of electric vehicles and front yard parking, because there are the two conflicting green directions, charging front yard cars and versus soft landscaping and stormwater management. Those are the things we're doing.
Absolutely.
I'm not debating that with you.
Yes.
I want to see if anyone else has questions with you.
Just I think one point of clarification. I think if you look at community planning's report, they also cite that the parking pad would be partially on city property, which, as we know, the city bylaw is trying to eliminate that kind of parking. So while it is landscaping, it's also the fact that they are prohibiting, for the most part, parking on city-owned property, parking pads on city-owned property.
Right.
And what's considered city-owned property?
Where your property line is in your front. So there is a right-of-way in front of your property. I don't know where it is. It's on your site plan, I presume. So the presumption is that where you're proposing your parking pad isn't 100% on your private property. It's partially on city-owned property.
Oh, okay. Is there anything else you wish to say, Lauren, about this? Go ahead with it. Whatever else you have to say about it, please go ahead.
Yeah, my intention is not to put any sort of concrete pad down. As you can see from the drawing here, right now it's just a grassed front. And so adding in lots of soft landscaping into that additional area, I will be putting in planting beds or other sorts of shrubs and things. So it's not intentioned to be just a concrete pad. I'll put in pavers, the grass pavers that can grow through so that there's appropriate water drainage, so anything that I can do that would be more reasonable and more environmentally friendly.
Lauren, is there a street parking spot in front of your house which will be lost as a result of this front yard parking spot?
Yeah, we rotate side to side of the street, so some months we're on the east side, the other months we're on the west.
Okay. Ms. Chan, you had another question?
Oh, I just want to add a comment that is, the transportation is also recommending refusal based on a different reason. They is because of you do not meet the minimum frontage requirement. Your lot is too narrow for front yard parking.
Okay.
That's I want to mention that. Yeah, it's not for
Thank
the
you.
landscaping reason. It's for the frontage.
Yes.
Thank you.
Minimum frontage. Yeah.
Okay. Ms. Hayes had a question too. Go ahead, Ms. Hayes.
I see that your neighbor at 501 has parking. Do you know whether or not they received permission for that?
They had parking when they purchased the house. The majority of the houses north on Main Street have parking. There's a few south that do not.
Okay, thank you.
Okay.
You're welcome.
Okay, at that, I think, panel, we're ready to take the application into committee. And so let's go into committee now. We can move to a motion unless there are comments in advance of that. Start off with Ms. Chan.
Oh, I just want to start with my quick comment. I think with the recommendation for 3 departments, I cannot really support this because I think that it probably is again is away from the official plan or the bylaw intention.
Thank you. Yeah. Mr. Clay?
Yeah, I sympathize with the applicant, and particularly as you noted, Chair. There is an ongoing policy conflict with electric vehicles and parking requirements that is as yet unresolved. We know the city is looking at that, and perhaps in the future will resolve it. But at the current time, we as a committee, at least the ones I've been on, we've been fairly consistent in not allowing these for the reasons that planning staff and transportation have provided us. So while I sympathize with the applicant, and there are existing parking pads that have been grandfathered in this and other neighborhoods, it doesn't seem entirely fair. But I think my view would be that I'm probably going to have to stick with what the current city policies are with respect to front yard parking pads, and particularly those that are on city property. So I unfortunately I can't support this one either.
Are you ready with a motion? Is anyone ready with a motion?
Sure. Just to get things started, I'll move a motion to refuse this application.
Thank you. That is seconded by Ms. Chan. So it is moved and seconded to refuse. Those in favor, please show of hands. And that vote is unanimous to carry the motion, and with that, the application is refused. The panel moves on to number 6, 170 Hope Street. And on 170 Hope, panel has before it submitted materials, plus a revised site plan, January 4, plus presentation materials received from the agent, January 4. There is comment from Community Planning of City Planning. There is both support and opposition. Correspondence. Support in the form of 18 form letters signed by the owners occupants of persons on Hope Street, Harvey Avenue, and these are received December 13 up to December 15. There's opposition correspondence from 137 Harvey. So let's have the agent join us, please.
Good morning, Mr. Chair. Can you hear me?
Hear you quite clearly. Good morning.
Wonderful, wonderful. Happy New Year to all.
Thank you.
This is Ida Evangelista. I'm speaking on behalf of the owners of 170 Hope Street. And before we start, I just want to confirm, we have worked with planning, and I just want to confirm that you do now have the modified variance number 1, which is 10.33%, and variance number 6, which has been reduced to 7.21 meters.
Let's go slowly here. Let's go slowly then. If we're
Sure.
actually going to be changing the variances, we need to go slowly. So the first item you mentioned, could you tell us what was that minor variance on the?
So the minor variance number one
Number one.
is the landscaping between the laneway suite and the home. And we have increased it to 10.33%.
So 0 becomes 10.33.
Correct, which
number
equates to 9.25 square meters.
9.25 square meters.
Correct.
Thank
And
you.
then variance number 6,
Number 6.
we have reduced the height to 7.21 meters.
Okay, so 7.77 is reduced, becomes less onerous to 7.21 meters.
And if you refer to Cecilia Wong, the planner, her email of January 4th, you'll see that she's also made references to those two variants that we have changed and worked with planning.
Thank you for that. So panel, we are dealing with an amended application here. Those are the numbers which you should be considering for items number 1 and number 6. Okay, panel members, do we, anyone like a presentation on this? Or are there any questions to put directly to the, okay, we'll go with Mr. Clay first, Ms. Chan second.
Sure. Just a quick one, Ida. So looking at the site plan, so
Yes.
where did you add the 10%?
So what we've done is, if you notice on the right side, so there was a garden always on the left side, and exactly where the cursor is being circled, we've added that that additional landscaping. When they purchased the house was purchased as is. You know, the garage, the backyard. So they have slowly been increasing the landscaping. But the way it is now, the 10.33, they also have permeable and drip lines that literally permeate. The backyard can actually maintain its own water. So that's where we have added the additional garden.
So the existing, so it looks like it's all currently concrete, is it? It's been.
It is.
Yeah.
So and they're rectifying it.
So I guess you've been down this road. Is there any opportunity to kind of remove some of that concrete or?
And that's what they're doing. And that's why we've increased it, because right now, as you see, it was 0. We have increased it. It's not a large backyard, it's a small backyard. And as we can see from the aerial photos, this is pretty consistent. So what they're doing and the way the sloping is, there is that swale, so they are able to maintain the water. And what they've also done is they've also created some pretty thick drip lines within the hardscape, right? That actually go right down deep to, I tested it myself, it goes right down deep into the ground, it permeates to the ground. And the additional landscape that they've created if you see at the site, on the site plan, you'll see the additional landscape that they've created. Pretty much, you know, if you look at it here, it doesn't look like a lot, but it is quite substantial.
Okay, thank you.
There was another question. Was it you, Ms. Chan?
A similar question. Are the drawings that you submitted reflected these changes? Both the reduction of the height and also the landscaping is already there, right? Yeah.
Yes, through you, Mr. Chair. Yes, a member. Even my submission that I sent in, you'll see that also includes the changes, and the drawings that you have also include the changes.
Okay, I have a question. We're back to soft landscaping here. Soft landscaping is something that we have really sharpened our focus on. The reason it is embedded in the bylaws because of the city's concern about it. So
Right.
I've listened to you, but I'm wondering. I mean, 10% is better than 0. But what actually is preventing that number? From having concrete torn up and going to 50%, for example. What actually stands in the way of doing that?
So it is a fairly expensive process and length. They also have grandchildren. This is an area that is very well trafficked, and the grandchildren do play out in the backyard. Be it ride their bicycles or, hit a basketball or play soccer, because on the street in that area is not quite an option. So that, we can increase it a little bit more, but if we can, and that's why when they purchased the house, it was like this. It wasn't something that they did. It was all like this. So, and that's why they actually put in several drip lines throughout the whole backyard. And just so that, the water will permeate into the ground. If the members, I don't want to throw the baby out with the bathwater. So if we do have to increase it, maybe to 12%, I can. But if the members, with the greatest of respect, if they can give them a little, because there is also a canopy area that just like shelter, like an umbrella for shelter. So with the greatest of respect, if we can move forward with the increase of 10.33%, they have gone through quite an extensive process to make sure and confirm that the lands are able to maintain its own water.
That's commendable, but with respect to your argument that grandchildren prefer concrete to grass, I cannot agree.
Yeah.
I don't agree with that one. Any other questions, panel, for the speaker? Mr. Reid, go ahead.
Thanks, Chair. Yeah, I have a question about variance 4 with the 45-degree angular plane. And I'm noting you have 7.8 meters between the main house and the laneway suite. Is that there just because of the additional height that you're requesting for the laneway suite?
My apologies. You cut out on me. Can you
Repeat
reiterate
the question, Mr. Reid?
For sure, yeah. My question is, with the 45-degree angular plane variance requested,
right?
And usually we don't see that when the laneway suite is greater than 7.5 meters from the main house, which that's a situation you have. So is that being requested because of the additional height that you're going for, the 7.77, or is that some other reason?
It's because the angular plane is not facing the rear of the property. It's not facing the house. It's facing Harvey. And that's why that's coming into consideration, variance number 4. And the reason being is just aesthetics purpose. It's much more attractive facing Harvey with the 45-degree plane.
Okay, got it. Thanks.
Ms. Chan, go ahead.
Okay, my question is actually just to continue with the variance number 1. I mean, you have suggested to increase to 10.33. And our chairman asking you whether you can do better, and that's my same question too. That's a big deficiency, and if you can increase it, limit some concrete, I think that will be much more supportive, this application.
Through you, Mr. Chair, would the members be satisfied if we increased it to 15%?
It's up to you to propose a number. If you wish to change it to 15, then we'll vote on it. But
I can vote. I can vote on. I can recommend 15%.
Well, then you should do it now, and I'm not saying that the members will go for it, but if you want to do that, that's fine. You'd have to give us that number plus the square meterage.
That's what I have to calculate, but we can increase it to 15%. But you just have to give me a minute
Take
to...
a moment, do your calculation. That's okay, take a moment.
Okay.
Okay, applicant, just ensuring you're still with us. Applicant, you should just confirm, please, that you're still with us.
I am. We're just calculating. I just want to make sure that it's absolutely correct, so no mistakes occur when we go to building permit stage.
Thank you, okay. Applicant, at this stage, I've got to have a mind for the keeping the meeting moving.
Mr. Chair, if you want to go to the next item.
Well, Chair, before you move, could I ask Ida one last question while the staff are working on this?
Go ahead. There's a question here for you.
It's about the height. We haven't really talked about the height. You're seeking almost 2 meters beyond permitted. 2 questions. One, is that, I guess, in part because the existing structure you're building on top and it's already tall?
Yes, through you, Mr. Chair, Member Clay. Yes, that is correct. Because the existing structure, which is quite structurally sound, we're just building on top of it, and that's why the second floor is just going to be an 8-foot ceiling height. The garage door is 12 foot currently.
Height tends to be something which gets the attention of neighbors, and there is no one that wrote in opposition to this. So can we assume that your client has discussed this with all the neighbors and there's no issues about the height?
Through you, Member Chair, Member Clay, we have the owners have gone around and spoken to all the neighbors that would be directly affected and beyond. And we've received 18 letters of support, all of which are all surrounding the property.
Right.
Great. Thank you.
Okay. Here's what I'm going to do at this stage. The panel is due a break right about this time, so we are going to hold this application. I'm going to take a 10-minute break, 10-minute recess, and when we return, applicant will be asking you for those numbers, and we'll proceed to take the application into committee at that time. So we're now in a 10-minute recess, and we are holding on application number 6 until we return. So recess to begin now. 10 minutes. Okay, we'll go ahead now. We resume, and we'll see if we'll ask the applicant to join us once again.
Mr. Chair?
Yes.
Okay, it's 15% increase, which equates to 13.43 square meters.
Thank you for that. 15% and meters, 13.43 meters squared. Very good. Okay, so we are dealing with an amended application here, and actually have changed the amendment to 15 from 10.33, the original amendment. Okay, panel members on 170 Hope, are there any final questions for the applicant before we take it into committee and move to a motion? Okay, I'm not hearing any, so Ms. Chan.
Okay, I can do this one because when I look at the first of all, the first it struck me was the height, but then when I look at the site, at this particular site is kind of odd. It's actually facing another main street on the other side, and I thought that actually in that case, when you look at the street, the extra height can fit really well, and then with the increase of the soft landscaping after our bargain, I would support this application as amended. Yeah.
Okay, any other thoughts on it? Okay, then, so is that a motion to approve then?
Yeah, I will move a motion to approve the amended and the revised agenda, and with no other conditions.
Is there a second to that motion? It is seconded, Ms. Hayes. So moved and seconded to approve the amended application. Those in favor, please show of hands. Those opposed, let the record show that Mullock is in dissent. With that, however, the application is approved, or the motion is carried, and the application is approved. Thank you. And we move on to number 7. 251 Dunvegan Road. On 251 Dunvegan, before us are application materials, revised site plan, Jan 4, photographs of trees on the property, cover letter from the agent, January 4, arborist report, January 4th, a ground floor study from McCarthy Tetro, January 4, and planning rationale by SGL, January 4. There is comment from Urban Forestry, and there is opposition from 253 Dunvegan, 502 Russell Hill, and 500 Russell Hill. So let's have the agent join us, please.
Hello, Mr. Chair. Mike Foderick here. Can you hear me all right?
Hearing you well, Mike. Yes, thank you.
So I act for the owner of 251 Dunvegan. I want to thank you for the chance to present today. On the file, you'll see, as you already referred to, a cover letter from me, as well as a planning rationale report from SGL Planning. They go into far more detail than I'm going to be able to do in 5 minutes about why this application and the variances within it meet the 4 tests under the Planning Act. So I urge you to look at that if you haven't already, but I'm going to just hit a few highlights that I think respond to some of the comments we're seeing from the neighbors, which I think will be the focus of this hearing today. I'll also say as a bit of a preface that there was a previous application for a very different building, a modern, unorthodox style, dare I say, building that was refused by the committee, and our intent is not to relitigate that today. I know that that was raised mightily in the opposition letters to this application, but that's a completely different application. The application before you today is very conventional, and dare I say, squarely in the green zone, so to speak, of other approvals that have been granted by this committee within this neighborhood and within 500 meters of the application, including on the subject sites. We hope this application is looked at with fresh eyes. I'll only say that within SGL's letter, there is a detailed table which shows the performance standards, in question, and compares this application to the previous application. And I think that table speaks for itself in terms of how different this is. It's a very different proposal. Building length, for example, which was 44 meters, is now 25 meters. I could go one by one, but I think I've made my point. I want to focus on the trees issue because that seems to be essentially the exclusive focus of the objections we've seen. And I'd ask the clerk if she could pull up the ground floor study document, which is there. You can see it available. I think this image, and if we could zoom in, this image really speaks volumes. And I also want to ask the committee to take note of the comments from Urban Forestry. There is a letter in which they say they have no objection to the proposed application. We met with them extensively. They reviewed this in detail. They met with our arborist, and again, it results in that letter which says no objection, subject to some fairly standard conditions, which we're of course happy to agree to those I would say straightforward conditions. What you see on the image before you, I think, speaks volumes, because you see the circles which represent the trees and their tree protection zones. There's two larger circles. The one on the left is the red oak, which you see referenced so much by the neighbors. That's the main tree, if you will, in question. And there's other things that this drawing, again, just it speaks for itself. In dark hatched is the existing building on site. That's the long-standing building, been there for decades. That's the existing building. In peach, that yellowish peach color. Oh, by the way, I should add, in addition to the existing building, you'll notice a porch which is attached to the existing building, which juts right into the tree protection zone. Also, you'll see in peach, that's the as-of-right massing. So if you wanted no variances from the committee and just wanted to build as of right with a building permit, that's the building you would build. And that's the building, frankly, that we will build if we get refused, if my client gets refused a second time for a different building than the one they're proposing now. And that as of right massing self-evidently comes much closer to the tree in question than what's being proposed. So you also see in blue, and it's just highlighted there for reference purposes, the previous application, and you see in red the current application, including a rear covered porch area, which perhaps shouldn't have been delineated, but we've delineated it there for thoroughness purpose. So a few big takeaways from this. First of all, when someone says, oh, you shouldn't build within the tree protection zone, well, the existing building is within the tree protection zone. As of right massing is significantly more in the tree protection zone than what it is we're proposing. And we're actually peeling it back from not just the as of right massing, but as you can see, we're peeling it back from the existing building envelope. So the net result of this, if you're concerned about this tree, as all the neighbors seem to be concerned about the tree, is that the net result will be an improvement over the status quo for that tree, at least if you think moving away from the tree is an improvement, which I do. So I think it's quite cute to say that, there should be no construction in the tree protection zone when not just the as of right massing, but the existing building is within that massing. I'll also note, by way of an aside, that there are no ancillary buildings, no landscaping and whatnot as part of this. We comply in every way with the landscape open space requirements and other, lot coverage and whatnot requirements that might be relevant. I'll just say in closing, I also want to turn your attention to, our height variances is where 11 meters is permitted, we're at 1153, right, 53 centimeters or 17 centimeters, depending on how you measure it. That's two variances right there. The FSI is 6.6 times, which is, very straightforward in this neighborhood. That table in my cover letter, and if you were to look at the cover letter and bullet 2 in that cover letter on page 4, it's something that I'd urge you to take a close look at.
I'll ask you for your final comments now, please.
It's this point, and if you look at that table, I think that speaks volumes. Out of the dozens and dozens of applications, it's not that table, sorry, it's under point number 2. If you scroll up to page 4, point number 2, is this to say that out of dozens and dozens of applications within the 500-meter radius, and even on this block, almost all of them, 90 out of 94 in the case of FSI, etc. I can go performance standard by performance standard, for the same or greater than the variances we're asking for, have been approved by this committee, have been found to meet the 4 tests. And I would submit we have picked a built form which is squarely within the green zone of things that the committee almost unanimously approves on this block in this neighborhood. Thank you for hearing me out. Subject to your questions, those are my submissions.
I want to begin with just an important thing with respect to the actual wording of what we're dealing with now. As distributed, the purpose of the application that we're dealing with includes a reference to a pool, and I want to ask you if that reference to the pool, if it's your intention to remove that from.
No, thank you for that, Mr. Chair. And in fact, the revised plan, so to speak, that were submitted were there to remove the pool, remove any ancillary structure. I'm not a fan of how that was described because there are no variances related to a pool. None of this application before you today do not relate to, so it can be amended to remove that reference. Yes, that's
Okay.
anything that.
So just a second. No, slow down, please. I want to. So right now, I'm just concentrating on the application as it reads for us. We're going to remove the sentence at the end of the purpose that reads, "Also to install an in-ground pool and pool terrace." Are there any changes to the variances themselves that you wish to
None
make?
whatsoever.
Okay.
None whatsoever, Mr.
So-
Chair. None of the variances related to that anyway. It shouldn't have been described that way, truthfully.
Okay. So we have then an amended application that we're dealing with. And panel members, any questions at this stage for the applicant? Mr. Clay, go ahead.
Just a quick question, Chair. I think it's beyond the purview of this committee, but I just wanted to confirm. I thought I read in the material that the excavation in and around the tree will be done by hand. Is that did I read that correctly?
Absolutely, sir. Again, that's something that I'm sure urban forestry will insist on. We've offered that in our arborist report, and I think the conditions that forestry has asked for speak to that to some degree, but we absolutely happy to commit to that, and it'll be done by hand and air spading and literally to the highest standards that not just our arborist, but that urban forestry wants. We will absolutely adhere to those because our objective is to actually move the building away from the tree, improve the situation for the tree. We'll do the construction means and methods, including that. Absolutely, we'll do it the way forestry tells us to the highest standards they recommend, sir.
Thank you. Okay, we're going to go now to the speakers that are standing by. And moderator, who is joining us first?
Jasmine Fraser, you have been unmuted.
Good morning.
Hello, Jasmine. You've been unmuted. We heard you temporarily. Through you, Mr. Chair, I'm going to get the second registered speaker to speak,
Let's
and
do
I'll
that. Okay.
re-establish contact with the first registered speaker.
Go ahead.
The second registered speaker is Max Laskin. You've been unmuted.
Good morning.
Good morning, Mr. Chair. Can you hear me?
Hear you clearly. Yes, thank you. You have 5 minutes to address the panel. Go ahead, please.
Thank you very much, sir. And I apologize. I'm just turning on my camera now. So, sir, my name is Max Laskin from Goodman's LLP. I'm counsel to the owner of 500 Russell Hill Road. You should have a letter in the file, sir, dated January 4th from our office outlining concerns with the proposal. Mr. Chair, members of the committee, this is a very strange application. It's not often that you'll hear Yogi Berra's words in the committee, but I'm going to use them today. Deja vu all over again. And that's, in my submission, what this application is. This committee, and in fact, most of the panelists that are on this committee with us today also heard the previous application for this same property by the same architect in September of 2020. And while the specific variances were different in magnitude, the basic approach to tree protection was the same. And while Mr. Foderick has noted that the application now before you has a different aesthetic, it's no longer modern in character. Frankly, the aesthetics of the building are not the issue. The issue is tree protection, and from a tree protection approach, this application is fundamentally flawed in the same way that the previous one was. And so, committee, not only was the last application for this property refused by you, it was also then appealed to the TLAB. And after days of evidence and argument, the TLAB concluded that the approach to tree protection was inadequate and did not maintain the intent of the official plan. And now, after this application has been roundly refused, a little over a year ago, it comes back to you with effectively the same approach to tree protection as I've noted. And that's why I describe it as deja vu all over again. And so, members of the committee, I urge you to refuse this application as both you and the TLAB did before. The core of my client's concern is an injury to a very old and very large boundary tree in the rear yard of my client's property. And if the committee could just look at page 6, 7, 8, and 9 of the document that's on the screen, I would appreciate it just a few pages down. The tree has expansive canopy that covers much of the subject property as well as my client's rear yard. And I apologize, Mr. Clerk, if you could just slide down a few pages to the images in Appendix A, I'd appreciate it. Those images show that it's among the largest and most prominent trees on the block and an integral component of the urban forest in this neighborhood. The tree also serves a critical privacy function for my clients. Yet the applicant has demonstrated a consistent lack of regard for the trees and the tree protection measures required. To start, I note that the application as submitted did not even include an arborist report or a tree protection plan. Indeed, the applicant's cover letter indicates that the arborist was retained after the application was submitted in September of 2022, which means that in the face of the explicit rejection of the applicant's previous proposed approach to tree protection, this new application was conceived and developed without advice from an arborist, which is frankly shocking in the context of the previous refusals. I also note that the arborist materials that were submitted late on January 4th, at the end of the day in the evening, at a point at which our client would not have an opportunity to respond in writing. And so I submit to you that you should be even more cautious about the application in these circumstances when there has not been an opportunity for a written response from a responding arborist. In any event, the approach to tree protection reflected is highly problematic. Attached to our letter is a report from Peter Kuntz, a registered professional forester, who notes that tree 28, which is the one you're looking at here, the very large one, is likely to have roots that traverse the entire width of the property. And yet the application proposes significant intrusions in even the minimum tree protection zone. There's a structural support system proposed that to support a cantilevered ground and second floor. There's the digging of a new window well in that area. And there's the excavation or removal of an existing foundation wall very close to the trunk of that tree. All of this will require substantial cutting and digging out of the root system. In addition, I would note that the arborist materials that were ultimately submitted in respect of the application show a tree protection fence that is just 1 meter from the trunk of the tree rather than at the outside of the tree protection zone. That, members of the committee, means that there's going to be heavy machinery and construction work just a mere meter from the trunk of the tree. That's a condition that Mr. Kuntz describes as a war zone for the tree and one that will result in tremendous root loss and ultimately a dismal prognosis of survival for the tree. I also note as the large tree that you're looking at here.
I'll ask for your final comments now, please.
Thank you. It misidentifies the large tree that you're looking at here as one that's less than half the size and incorrectly assumes that a portion of the tree a portion of the ground next to the tree has no roots, only because of the porch that Mr. Foderick mentioned. That porch, Mr. Chair, members of the committee, does not have any below-grade structures, so there are, of course, roots in that area, and yet they are proposing to dig exactly in that area. The last thing I will say, Mr. Chair. Thank you, sir. Appreciate your time.
Thank you. Panel members, questions for this speaker?
Yes, I do have a quick one.
Go.
Yeah, sorry. To this speaker, are you aware of the memo from Urban Forestry dated January 5th that they recommend some conditions which regarding to protection of the trees and also the whole process of getting their approval?
Thank you, Ms. Chan. Thank you for the question. Yes, I am aware. Ms. Chan, that report from Urban Forestry is dated January 5th. That is the next day after the arborist report was submitted on the evening of January 4th. And in my submission, Ms. Chan, that report should be given very little weight in that circumstance. Staff cannot have possibly digested the materials within 12 hours to develop a proper view on the application. And in any event, the more important point is that staff did not have the benefit from of responding materials from Mr. Kuntz and another professional arborist to provide other perspectives. And so, Ms. Chan, I don't believe that report should be given any weight in this proceeding.
But it's given by the Forestry Department. Do you think that we should ignore that? That's what you're suggesting, we should ignore that?
I recognize that it was given by Forestry Department, Ms. Chan. I'm saying that my submission is that the advice of Mr. Kuntz, which was accepted by the TLAB in the previous application, should be preferred over the very simple report prepared by staff just 12 hours after a voluminous arborist report was submitted.
Thank you.
Okay, thank you. Yeah.
Okay, then we'll go to the, oh, Ms. Hayes, go ahead.
So, what, if any, development do you think, do you believe that any development beyond the boundaries of the existing home are permissible that would allow for the protection of that tree?
Thank you for the question, Ms. Hayes. I do. And I think that development would involve avoiding the tree protection zone to the extent that the existing foundation exists. So just as an example, the cantilevered ground and second floor, which the applicant has proposed and is related to the density variance, requires structural support within the TPZ. That is not necessary to support a home that is still much larger than what is proposed, than what exists today. That cantilevered portion is not necessary, Madam Chair, and that involves intrusion. I would also note, thank you to the clerk for pulling that up. I'd also note that the window well that's proposed that you see there in that sort of elbow area, that too involves substantial digging of the root system very close to that tree, and that too could be avoided through redesign, Madam Chair. And so it's in respects like this that the design of the building does not appropriately account for the protection of that tree. And there are ways, Madam Chair, Ms. Hayes, excuse me, for the development to proceed in a manner that would properly protect the trees.
Thank you.
Thank you.
Okay. Let us proceed to the next registered speaker.
Jasmine Fraser, you've been unmuted.
Good afternoon.
Good afternoon.
Can you hear me?
Yes, we do hear you now. You have 5 minutes to address the panel.
Perfect. Thank you very much. My name is Jasmine Fraser, a lawyer at Airden Burles. I represent the owners of 502 Russell Hill Road, the property that backs onto the applicant's east side yard. And if I could ask committee staff to pull up the map that's attached to my written submissions. To give brief context, as we have already noted, the application before the committee today is the second application for this property. The first one, for virtually the same relief, was refused by the TLAB in 2021 because of the impact on the boundary trees. The applicant has now come back a second time and have not properly engaged my client. My client filed a letter of opposition on January 4th and subsequently a request for deferral on January 9, and I will address each in turn. Regarding the deferral, a week before today's hearing, the applicant filed over 100 pages of new materials, including revised plans, a cover letter, a new planning justification report, and significantly, a new arborist report and tree preservation plan. None of those supporting reports were filed with the original application back in September. My client did not find out about the new materials until after the submission deadline. As you know, my client's chief concern is regarding the survival of those boundary trees. The last minute filing, particularly the arborist report, is unreasonable, unfair, and undermines my client's participatory rights in the public process. First, I know the applicant had ample opportunity to file these materials in the 3 months leading up to the hearing date. There's no explanation provided for the late filing. Second, we filed a letter of opposition on the materials that were available at the time, and that did not account for the applicant's arborist report. The late filing has not permitted my client and their consultants to thoroughly review and respond to the new information. Third, the applicant did not file those materials within a reasonable time frame to allow my client to make an informed submission. The right to make informed submission is particularly important in light of the recent removal of third-party appeals. In the event that the committee refused my request for a deferral, we ask the committee to refuse the application. In 2021, and I commend the TLAB decision to the committee, the TLAB found that cutting roots outside the minimum tree protection zone does not provide a suitable environment for growing trees, which is contrary to policy 341D of the official plan. While the proposed footprint in today's application is slightly smaller, the issue of the boundary trees remains. The applicant's arborist report does not address the damage that could be done to the roots outside the minimum tree protection zone. And it is the evidence of my client's arborist that damages outside of that zone is very likely to reduce the prospect for survival of those trees. The variances proposed is contrary to policy 341D of the official plan, as noted, which requires that development preserve and enhance the urban forest by providing a suitable growing environment for trees and increasing tree canopy coverage. This policy goes beyond maintaining the status quo and requires an enhancement of it. The applicant has not demonstrated that the proposal will do just that. Their arborist report notes that the boundary trees are in very good condition and that the proposed construction will impact their minimum tree protection zone. Nowhere in the applicant's materials address how the proposed variances maintain this particular policy of the official plan. As a final note, we urge the committee to refuse the application, particularly in the presence of competing expert opinions about the trees that have not been tested through examination. It is fair to conclude from reading both arborists' report that there is a real possibility that the construction could significantly damage.
Comments now, please.
Yes, I will conclude. Thank you, Chair. And any damage to this tree may result in a loss that is irreversible if not properly protected. In the event the committee approves the application, we ask the committee to make the protective measures recommended in the applicant's arborist report as a condition of the variance approval and include those measures in any permit to injure the trees. Thank you for the time.
Thank you. Panel members, questions of the speaker? All right, then let's move to, I believe there's one more speaker.
Keith Van Winters, you've been unmuted.
Yes, good morning, Mr. Chair. My name is Kees Van Winters. I'm the owner of the property right next door to the proposed proposal at 253 Dunvegan Road. I have a number of concerns regarding the property. Certainly, the trees are of great concern to just about the whole neighborhood because they are monumental trees, but I think that's been addressed by the two previous speakers. I also have some other concerns. One is the setback that the proposal is asking for. I don't understand any reason why the zoning bylaw should be changed for this house where the setback is 2 meters less than what is called for in the plan, other than, I guess, having a larger backyard that they would have with the setback. All of the houses on this block are set back the exact amount as required by the bylaw. This house would be an exception. The house next door on the other side at 249 Dunvegan is set back closer to Dunvegan Road, but it abides by the setback rules for Russell Hill Road, much like the one across the street at 496 Russell Hill Road. So they really cannot be compared. 251 Dunvegan Road should be the same as 253, 255, 257, 259, and 261 Dunvegan Road. All of them are set back by the required 10 meters. The other great concern I have, is the length of the house. Again, all of the houses that I previously mentioned on the block have no greater length than 17 meters, which is what the the zoning bylaws are calling for. This house is looking for a length that is 50% longer than that at 25 plus meters. It would create a precedent on the block. It also would create some concerns regarding sunlight and other light, and would concern the privacy that we all have now, we all enjoy in our backyards. Thank you.
Thank you very much. Panel members, questions for this speaker? I have a question, Speaker, and that's with respect to, I think, what was almost your last point there, which relates to variance number 1. That additional building length, can you tell us the impact that would, the kind of impact that would have on you as you're the neighbor right next door? What kind of impact will that have on you?
I am just this property is to the east of me, so therefore it would impact on A, on my privacy, and B, on the light coming into the backyard.
Okay,
it would also mean that I am looking at a solid wall for another 50% of the length of my building and of the current building, and that seems excessive to me.
Thank you very much for that. Okay. Okay, then, we'll go back now to the applicant's agent, and who will have a chance now to speak in rebuttal, but only to the issues that were raised in the speaker's submissions. So go ahead.
Thank you, Chair. I'll try to get to all of them. So several points were made about this, somehow some suggestion that our materials were submitted late. I think that's an absurd statement. They were submitted in accordance with the rules, the deadline for the rules. There is no requirement, in fact, at all to submit an arborist report, to submit a planning report, for me to submit in advance my speaking notes as I've done. Many applicants don't submit anything like that ever. We do that. I try to do that because I think it assists, given we only have 5 minutes. And so we submitted it by January 4th. So to suggest that somehow it was late or something, I just couldn't disagree more with that. Furthermore, to the extent that one of my friends was talking about a late arborist report and whatnot, this is from someone who submitted an arborist report on the exact same day. But he wants you to put great emphasis on his arborist report, accept his arborist report, but the one I submitted was late and shouldn't be considered for that reason. I don't understand the objection. The notion that somehow forestry was surprised by this, they were not. I alluded to this in my opening remarks. We've met with them extensively. They have seen Alora, our arborist, is on the line and will be prepared to answer questions if the committee would like to hear from her directly. But she's met with them extensively. That memo was not arrived at by forestry without giving them much comfort as we've given them. And my friends both mentioned, I think it's the only actual test anyone actually made reference to. They mentioned this official plan test. Well, forestry has helpfully in their memo quoted that specific policy and indicated, including with consideration of that policy, that they have no objection. So if you don't believe me, if you don't believe our arborists, I hope you would believe forestry. And further, everything we've heard is about construction means and methods. It's just not something that, and by the way, none of the variances in question actually relate to the setback to the tree in question. As you've seen, the as-of-right zoning envelope would allow us to get much closer to the tree. The existing building allows us to get much closer, is much closer to the tree than the proposed building is. We're trying to improve the situation of those trees, and this is heavily supervised by the tree permit process. And I assure you, I think this committee knows how diligent forestry is, and they will not issue that permit unless they're satisfied with what our plan is and how we're doing it. And they wouldn't have issued the letter they have unless they thought that it was something that they could support. I will speak briefly to this, and again, I'll just say in closing about the trees, this notion about a war zone, etc. That is completely, again, there's nothing, no variances related to matters outside the tree protection zone. No variances related to even that part of the property. So to suggest that somehow the committee should refuse it on that basis, it's just pure speculation on the part of the other arborist, and I think even he would concede that. And it's just not something that's the subject of any of the variances. Again, I would urge you to trust forestry's well-considered opinion on this. Briefly, in respect of Mr. Van Winter's points about setbacks, I think that table I showed speaks for itself. 8 proposals on Dunvegan alone for greater. So this notion that we're the deepest is absolutely false. We're nowhere near the deepest at 25 meters in building length. The previous application, which my friends seem hung up on, which is not before the committee. It was 44 meters long. That was outrageous. I see that. We're at 25 meters, very different. My friend characterized it as almost the same or something like that. I don't think anyone could honestly say that 25 meters is almost the same as 44. It's extremely different. And so at 25 meters, there's at least 8 examples shown, 8 of 8, I might add, shown on Dunvegan alone, which are the same or greater. And with a 500-meter radius, 30 or something examples. In fact, Mr. Van Winter's own neighbor, I think it's 257 Dunvegan, I'm advised, has a 30-meter variance for building length. It was just approved the other, oh, pardon, at 240. I have the address wrong, but it's his immediate neighbor, I'm told. The point is that to suggest that somehow we're the first one to ask for a variance beyond the performance standard is just completely false, and it's at odds with the research set out in that SGL report and my cover letter. Finally, on the front yard setback, which I'll speak about briefly because I haven't spoken about it yet. The whole intent and purpose of the zoning bylaws, I think this committee knows, is averaging, right? So you want to have a front yard setback that's sort of relative to what your neighbors are, and so you take the average of the neighbors, and that dictates what your setback is. We're in a situation where the building 249 Dunvegan on one side of us is very close to the sidewalk, and we are in between the two. So we respect the intent and purpose of the bylaw. That property, though, fronts on Russell Hill Road, even though it has a Dunvegan address and it presents on Dunvegan and they use that as the front door. So we've respected the intent and the purpose of the bylaw by taking that averaging between that and the neighbor. The bylaw strictly read says you don't account for that building which fronts on a different street, but we very much respected the intent and purpose. The same approach.
For your final remark now, please.
The same approach that immediately across the street took to that front yard setback, which was also approved and in place already. We've mirrored that. So thank you and Lori is available to answer questions or arborist if the committee so decides to hear from her.
Thank you. Panel members, questions for the agent, or perhaps you want to put questions to the arborist, who I understand is standing by. Any questions? Ms. Hayes.
Thank you. What is the depth of the house up to the covered terrace at the rear?
I'll ask you to pull up the ground floor study again. I think the pictures say it speak 1,000 words. I think that's a better than all just describing it in numbers. Yeah, let's zoom in on that. So you see that in red is the current proposal. I say again, the yellow is the as of right massing, and the hatched dark area is the existing structure, including that little deck area there. So that rectangular box at the back in red is the covered porch of sorts, and the rest of it is the house itself.
No, I see that. One of the reasons I'm asking is the covered terrace on the west side, I guess, is it's not open. Right, it reads as a solid wall, correct? That's why I was asking the question.
You mean? Oh, I see. You're thinking about in respect of sort of the neighbor's view, so to speak.
Well, I'm just trying to.
No, it's an open porch. It's described as a porch there, so it's open. It's not going to be a solid wall. If there was a desire for the committee to make it clear that that's an opening, I have zero problem with that. If that were specified, it should be. Anyway, we're happy to.
Okay, because when I look at your elevations, it doesn't look open, so that's why.
Okay, I'm noticing that now as well. If that's a thing that's important to the committee, we're happy to make that change.
Well, I'm just at this point of time, I'm just seeking clarity.
Yeah, no, I'm seeing that it is on the elevation. My friend is showing me it is a closed wall. I'm mistaken. I think it's open to the back but closed to the side. That's my mistake. But we're happy to modify that if there's a desire to. I would reiterate that we're not the deepest on the block, not even by a long shot, and there's multiple other approvals deeper.
Okay. Are there other questions for Mr. Clay? Go ahead.
Thanks, Chair. I'd like to beg the indulgence of the committee. I think the most contentious issue here is clearly the tree, you'd mentioned that your arborist is available. I would think we would all benefit, and I appreciate there's no opportunity for the opponents to question what we're going to hear. But I'd like a very short, very brief overview from the arborist about the impact of your proposal on the tree that's in question.
Her name's Laura Watson. If the committee
Let's hear from her,
secretary-
please.
Through you, Mr. Chair, that person has not registered and isn't on the registered speakers list. I do not see that person in the registered speakers list.
Okay, we do have an issue there. That person should have been registered in advance. So
Okay.
I'm sorry that's a problem. Okay. Any other
Well, that's too
questions?
bad because I
Excuse-
think we would benefit from that.
I think we would too. It's a shame that the applicant team didn't pre-register
Well,
that person.
if it assists the committee,
It is a problem, Mr. Foderick, because the person's not pre-registered.
If it assists her, I mean, we can stand down long enough to get her on the line. I'm
I've said
happy
it
to
was.
do that.
I've said it was a problem because she was not pre-registered. Are there any other questions for the Mr. Foderick panel? Okay. In that case, it's time to.
Sorry, Mr. Chair, I just have one other question.
go ahead.
Sorry, maybe minor. I'm looking at the site plan again, and I know the pool terrace and the pool have gone. On the site plan, I don't know if it's not a gate, but is it looks like a very solid fence, sort of
Where are you looking at?
on the fence line on the west side. What is that?
And if you could just point to what you're talking about.
Sorry.
we can't point.
Well, I
No.
can't. I can't.
Okay, sorry. On the west side of the property, I think.
Oh, now it's. Oh, sorry. It's not. Okay, it's not on the revised one. Sorry, I'm looking at.
Nothing in the rear yard is asking for a variance.
Okay.
There should be nothing should be
Okay,
landscaping,
thank you.
grass.
I was looking at the older
Okay.
site plan. Thank you.
There's the answer for that. Okay, then, at this stage, we shall take this application into committee for discussion. And Ms. Chan, you can lead off.
Yeah,
Go ahead.
we'll start with a comment responding to Larry's request for the arbor's presentation. But Larry, if you look at the memo by Urban Forestry, that one of the conditions or requests by them that despite whether we approve or refuse this application, in terms of removing or injuring any tree, they still have jurisdiction over us. So in that memo, it says they request them, they have to work with them anyway. They're requesting a workable method to protect that tree.
Yeah, and that's helpful. Yeah, I appreciate that. I thought my only concern was I thought we might benefit. I've scanned the arborist report, but I would have enjoyed hearing firsthand.
Yes. Of course, yeah.
what the conclusions
Because
of
we
that
cannot get them connected, so I thought that maybe.
No, that is helpful. Thank you very much.
Yeah. So the other comment is that I remember I was, and also Peter maybe, was on the previous hearing on the larger scheme. If I have to make a comment on this one, is that it actually is significantly reduced. And we are not looking at the same conditions anymore in terms of the length, especially, and also with the terraces. With the pool and all that. We are not looking at any of that. And in my opinion, and also my experience, is that because they are at the end of this row of houses, and the other houses on the east side is actually sticking out more. So the argument on the front yard setback, I think it is a very good argument given by the applicant, and I can accept that. And overall, I think if you were on the last scheme, you understand how much they have come this way, and I, this time I'm willing to support it.
Okay, thank you. Other thoughts? Mr. Reed, go ahead.
Thanks, Chair. Yeah, I remember this application well from last time. I do share the concerns of the neighbors and my fellow panel members with regard to the tree, but I think I have to just kind of defer to Urban Forestry to sort that out. And I do think that what's being proposed from a kind of footprint perspective of the house is not significantly different than what could happen as of right, almost, in terms of its relationship to the tree. My main concern is the length and depth still. And Joanne raised this before, and this was a major concern of mine last time, is that the materials consistently refer to the basement level, but the first floor, the covered porch, reads as a story, as a tall story. The west elevation is completely covered, and so it goes, this is 25 meters longer, 25 feet longer than what is permitted for the height. That's a lot for me. The east side is partially covered on the facade, and the rear is open. So I think that first floor, that covered porch, reads as a room from the neighbor's perspective. So I won't support this application.
Other thoughts? Panel? Mr. Clay, go ahead.
Thanks, Chair. I think I was originally concerned about the boundary tree, but I have looked at Forestry's report, and Yim makes a really good point that, and I think we can make it a condition as per Forestry's recommendations, that if we were to support this, that nothing could be done without their input and their approval. And I did note that the foundation being proposed is actually set back from the current foundation, and any excavation is going to be done sensitively by hand. So that gives me a little bit of comfort. I'm not as fussed about the actual structure. I appreciate that it does exceed the length, but it is and it is covered on one side, and it does have a roof structure. But I look at, these are very big lots, large homes on these lots. I think the lot and the lot fabric in this area can accommodate that additional length, and the massing of the actual structure is such that the upper story is set back. This is a style that and I'm not sure if others have, but I think we're starting to see more of this type of style in these types of neighborhoods, and it in my view, doesn't negatively impact the neighborhood, and I think it's the kind of proposal on these large lots in these neighborhoods that I think can be accommodated. So I'm not uncomfortable with this application, given the conditions that are in play and the proposal before us.
Thank you. Thank you. All right. Ms. Hayes, do you want to weigh in or not?
Well, I'm struggling with the wall on the terrace and how it reads from a massing perspective. But overall, I don't think that the variances are out of character with the built form that's in this neighborhood. They are large lots. I wish they could treat the wall to the terrace in a different format. But overall, I think I can support the application.
Okay, thank you. For my part, with respect to the tree, I am comfortable relying upon urban forestry to use their always good scrutiny to resolve issues around that tree, which are important. The length issue, it is a tough one. It's really just on, the lots are very large. But overall, I was persuaded by the argument that the Case Van Winter made with respect to it and the impact on his property. So that did persuade me not to support the application. So I'll look for a motion on this. Ms. Chan, go ahead.
I will try to make a motion for approval with the revised purpose clause, and also put a condition on to adopt the urban forestry memorandum dated January 5th.
And this is approval of the amended application, of course. It's
a revised purpose clause,
yes.
Amended, yeah.
Very good, very good.
Chair, just before we vote on this, I'm thinking about Joanne's comment. Is there any condition that we could put if in fact you're going to be supporting it, but is there any condition we could put on that would address your concerns about the rear terrace?
Well, I think there may be, if we can sort of build off the comment that was made that they can change that if the committee prefers. I would like to try to. I think that would be make it a better proposal from an impact in terms of that solid wall across the back.
So was the proponent suggesting to make that open rather than enclosed?
Mr. Chair, I don't know if it would be appropriate if we could go out of committee to ask the applicant that question.
I think it is appropriate. Yeah.
I have a comment here. Don't forget, there's also a full. I do not know. I just assume this fence is not too low.
It's not the fence. It's the
I understand. No, what I'm trying to say is I understand, but in order to sort of minimize the impact, if you ask them to open that wall, that the fence is still there. I mean, you might improve it by a little bit. Right?
Well, the fence
is still
can only be
solid fence.
A fence can only be 6.5 feet tall, right?
Yes, exactly. So I'm not too sure how much improvement, but I also a bit nervous is to sort of design, give them a design way on the fly. Because they have a fireplace there, so we're going to, or cooking, whatever, stove. I'm a bit nervous to say, unless they give us a proposal with even pencil mark, how big is the extent of the wall. I'm not willing to put that as, if I'm going to move a motion, I'm not going to include that design.
Well, I think it's appropriate, as Ms. Hayes was suggesting, to come out of committee for a moment, to talk to the applicant, and to see if the applicant can suggest succinct language quickly that would deal with what Mr. Clay and Ms. Hayes have in mind. So let's do that. So I'm going to go out of committee now. Applicant?
Hello there, sir.
So we're asking you for some language here. Do you see the thrust of what these?
Right. I'm hearing the concern as being the west side, if you will, of the covered porch, and that
reads up, please.
Reads as a wall. I think is what someone said. So we're happy to a condition that would say, subject to the covered terrace. The western wall, as you can see, the back and the other side are open. We could say that the western elevation of the covered terrace is open, subject to the condition that something like that. I think that wording would probably work. Subject to the western wall of the covered terrace is open.
Thank you. Let's just pull it up and of the covered rear first-story terrace, correct?
Correct. Yeah.
I think that may be sufficient. Okay, leave that up, please. That drawing.
I didn't think it was controversial, sir. We would have made that change up front if I had anticipated the possibility that would have been controversial.
Okay, we're gonna go back into committee now, Mr. Foderick. So thank you for that suggestion, and we're back in committee now.
Okay, so, Mr. Chair, I'd like to also add to that. We just assume this is what the neighbor wants. To me, it seems that the wall gives them more privacy. I'm not too sure. We're doing some design that is not without any consultation with the next door neighbor.
Here's how we're going to deal with this. Mr. Clay and Ms. Hayes, if you wish to suggest an amendment to the motion that has been made by Ms. Chan, then you can do so now, and we'll vote on the amendment. And then we can, if it passes, we'll include it in the motion.
But it's Miss Chan's motion, so she's not prepared to amend it.
It's Miss Chan's motion, but no,
what is the amendment to have an open wall on that side?
It would, it would be that on the western wall of the covered terrace on the first floor be open.
But there's a barbecue and some counter, so it will be at least like about 3 feet high, right?
I think we have to deal with it this way.
No, I understand the challenge, yeah.
Okay.
I'm so sorry. I think that I maybe someone else can make a motion to that effect, but my motion, if being voted on, is fine. I just would like to keep the same motion without that amendment of the wall.
Well, we can do that, or they were, Ms. Chan, what was happening here was that a friendly amendment was being suggested, but if Ms. Chan or if Ms. Hayes and Mr. Clay wish to make an amendment to the motion, they may do so by making a secondary motion, which we can vote on, to include or not to include in the original motion. So do you wish to do that?
Just a suggestion, maybe a compromise solution, not to belabor this point, but compromise solution that that the owner consult with the next door neighbor and agree on whether that wall be open or closed.
I don't think we have a way of enforcing that, though, do we?
That I think makes more sense because you have to involve.
That's not enforceable, though.
It isn't, but again, I think it sounds like it might be a solution.
Would you include that in your motion, Ms. Chan?
Or we just go with Yim's motion and it goes or not? I don't know.
Yeah, I'm agnostic about it, yeah.
Okay, all right.
Ms. Chan, would you be willing to include Mr. Clay's suggestion in your motion that the applicant and the next door neighbor at 253 would...
Through you, Mr. Chair, that's not a condition.
What I would like to do...
Sorry, Ms. Chan, through you, Mr. Chair, that's not a condition that can be enforced.
We
It's
can't
not to the
enforce it.
satisfaction of anyone.
No, that's fair enough.
Okay.
That's exactly what I'm trying to say. I will keep my original motion, which is just to have the revised a purpose clause. We
Ms.
can
Chan?
put a note. Sorry.
I'm sorry to interrupt you. Go ahead, please. Complete your motion.
But that was my motion, and also we can just add a note at the end of the decision to suggest or encourage the applicant to discuss with the next door neighbor on the treatment of this wall or the cover or the porch wall.
Through you, Mr. Chair, we cannot include that in the decision. It would be for the record in the minutes.
Okay, that's the...
Okay.
I'll second that, Chair.
It is seconded. So it is moved and seconded to approve the amended motion. All those in favor, please show of hands. Those opposed, please show of hands. Let the record show that Mr. Reed and Mr. Mullock are in dissent. But with that vote, the motion is carried and the amended application is approved.
With the forestry memo, the condition
Yes.
adopt
It is approved as amended, subject to the forestry condition.
Very good. Thank you, panel. Very good. Okay. With that, we move on to item number 8. One Frizzell Avenue. On this application, the committee has before it the submitted materials and an arborist report dating to September the 10th. Let's have the applicant join us, please.
Hi, good afternoon, Mr. Chair and members of the committee. Happy New Year.
Good afternoon. State your name, please.
Sean McGaffey, W&D Associates, 90 Eglinton Avenue East, Suite 970, Toronto, Ontario, M4P2Y3.
Very good. Okay, I'm going to check Mr. McGaffney with my colleagues to see if they require a presentation or whether they might have questions to put directly to you. Any questions? Any requests for presentation? No. Okay. Not hearing any questions, so that being the case, is anyone ready with a... we can take this application into committee. So doing so, we would remove the, okay, we're in committee now. Anyone ready with a motion? Mr. Reed, go ahead.
Thanks, Chair. I think this is very straightforward and the type of redevelopment that's happening on the street and in the broader neighborhood. The variances are minor, and I move approval of the application with no conditions.
Thank you. That is seconded by Ms. Hayes. Moved and seconded to approve. Those in favor, show of hands, please. And that vote is unanimous. The motion is carried and the application is approved. On number 9, 8 Humewood Drive, I am recusing, and I am passing the gavel now to Ms. Hayes, who will serve as acting chairperson for this application.
Okay, thank you. So the matter before the board is 8 Humewood Drive. The committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, email correspondence from the supervisor development planning and review transportation services, staff report from the acting supervisor tree protection and plan review urban forestry, letters of support from 6 Humewood Drive, and other letters of support from 4, 11, 12, 13 Humewood Drive, 293, 297, 299 Rushton Road, and 7 Humewood Drive, and correspondence in opposition from 295 Rushton Road and 9B Humewood Drive. And I believe we have an agent, Mr. Laszlo, to speak, as well as 3 speakers, 2, I believe, in opposition. I'm not sure about the speaker from 10 Humewood. So, Mr. Laszlo, could we have you on the line, please?
Drew Laszlo, you've been unmuted.
Could we have your name and address for the record, please, Mr. Laszlo? Lazio, sorry.
Laszlo, thank you. I'm Drew Laszlo.
I was right the first time.
Yes, correct.
It's spelled wrong on one of the submissions here, sorry.
Thank you. Drew Laszlo, agent for the owner. Address is 93 Rowe Avenue in Toronto.
Okay, Mr. Laszlo, because we have opposition to this matter, we'd like a presentation, please. You have 5 minutes. Your time starts now.
Sure. The application today is for a garden suite, and there are an additional 5 variances. So the first 4 variances are for the garden suite itself. The final 5 variances, making that 9 altogether, the final 5 are to legalize existing accessory structures that are already on the property. Variance number 1, I'll just quickly go through the variances. Variances numbers 1, 2, and 3 are all related, and they all have to do with the fact that the proposed garden suite is not 7.5 meters from the proposed main dwelling on the property. So variance number 1 has to do with the angular plane, which is taken, which is measured 7.5 meters from the existing dwelling on the property. But because we are proposing to be located 5 meters from the existing dwelling, we cannot conform to the angular plane requirement. Variances number 2 and 3, for all intents and purposes, they are the same, and they refer to the height of the property. Again, because the proposed garden suite is not 7.5 meters from the existing dwelling on the property, we are limited to a height of 6 meters. But I think it's important to, we are limited to 4 meters in height. And that's what variances 2 and 3 have to do with. If the, I think it's important for the committee members to know that if the proposed garden suite was located 7.5 meters from the main dwelling, we would, as of right, be able to build a garden suite at 6 meters, which we are proposing today. Variance number 4 just has to do with the eaves along one side of the garden suite. The eaves is only allowed to be 1 foot. To project 1 foot, we're projecting 1.5 feet, on one of the sides, the south side of the proposed garden suite. Variance number 5 has to do with the front yard parking space. We want to legalize the existing driveway and make that a legal parking space. We are not touching the driveway. It has existed for 25 years. It will remain exactly the same. The only reason that variance is required to be able to park in the front yard is because we're eliminating our garage. So because we're eliminating the garage on the property, now we need a variance to be able to park on the existing driveway. Variance number 6 has to do with an existing garden shed located at the rear of the property. We're off by about 1/2 inch as far as the side yard setback of that garden shed is concerned. Then there's a chimney, variance number 7. It's a chimney, and it's made for birds to nest within that chimney. And it is approximately 16 inches higher than what the bylaw permits. So we need a variance for that existing chimney. Variance number 8 has to do with a chicken coop we have at the back. Again, that's an existing structure. The use itself is not permitted as far as the bylaws are concerned. It is under review and for all intents and purposes is permitted in the Toronto Municipal Code. And we are expecting within the next year or so that it will be incorporated, like being able to have a chicken coop will be permitted. And we're expecting that to happen plus or minus within the next year or two. So that we need a variance for that. Final variance number 5 just has to do with the eaves of the existing garden shed. And again, it's encroaching all the way to the property line. We're supposed to be 6 inches from the property line. Again, that's an existing structure, which we're just trying to legalize. Thank you.
Thank you. Panel members, any questions at this time?
Yeah, Chair.
Okay, Mr. Clay?
Quick one. So the obvious question to me would be, and I didn't hear you refer to this, but why the garden shed couldn't be moved back a little bit to improve the separation distance with the house. I'm assuming, looking at the site plan, it's because there's a tree there?
Yes, number 1, we'd like to retain that tree, and the committee, it's probably not very obvious on this, but we actually have no foundation. Like we're kind of going out of our way to damage that tree as little as possible. We have no basement that goes within the TPZ of that tree. So we're even taking it to the next level. So that's exactly right. We don't want to push it back to not damage that tree. One thing the committee should be aware of also is, so the existing garage that's on the property right now is 2 meters or 6.5 feet more forward than where the proposed garden suite is. So we are actually pushing the garden suite back as much as we can to get as much distance from the existing house as we can and to save the tree. So we're kind of trying to meet in the middle.
Any other questions, panel members? Okay, staff, could we have the first speaker, please?
Nathaniel Gold, you've been unmuted.
Good afternoon, Mr. Gold. Could we have your name and address for the record, please?
Hi, yes. My name is Nathaniel Gold, and my address is 10 HUMEWOOD Drive.
Okay, and you're speaking in opposition to the matter?
I am, yes.
Okay, so you have 5 minutes. Your time starts now.
Okay, thank you. Good afternoon. My name is Nathaniel Gold, and as I said, I live at 10 HUMEWOOD Drive. My family and I live next door to 8 HUMEWOOD Drive and are immediately to the north of the subject property. We have 2 young children and are very concerned about this proposal, specifically with respect to variances numbers 2 and 3. The current bylaws state an ancillary building must be no more than 4 meters tall and located no less than 7.5 meters from the existing residence. In this case, my neighbor is proposing to build the garden suite 5 meters from his house with a height of 6 meters, which is 50% higher than the law permits. My neighbor is proposing to have his garden suite 6.5 feet taller and 8.2 feet closer to the residence than the bylaw permits. This means whoever is living in this garden suite will have easy access to look directly into our windows and directly into our backyard where our children play. The proposed house is too tall and too close to the existing residence, which as a result means that the proposed house is too close to our family home. With 2 young children, this is extremely concerning to us. We have a right to privacy in our own home and in our enclosed backyard. If these requested variances, which my neighbors put forward, do pass, whoever is living in this garden suite can look directly into our bedroom windows. In addition, because of the large trees that surround our backyard, we currently get very little sunlight. Because the garden suite to the south of us is 50% higher than permitted, there will likely be a complete obstruction of any remaining sunlight in our backyard. This means the garden suite will cast new shadows, leaving little sunlight, giving us little to no opportunity for gardening in our backyard and our kids enjoying sunshine in there. The height of the garden suite and in close proximity to our home will make this proposal very concerning. As a young family with a young daughter, we expect to have privacy. I thank you for taking time to listen to my family's concerns.
Thank you, Mr. Gold. Panel members, do you have any questions? Mr.
Chair,
Craig?
yep. If I could, you're concerned about the proximity of this proposal to your house. We heard the applicant say that they're trying to save the tree. That's why they haven't pushed it back further. Are you similarly concerned about that tree?
I'm concerned about trees in general, but not that tree specifically. If they wanted to push it back, it can be at the normal height of 4 meters instead of 6 meters. And that would save that tree the same way. If by pushing it back to 7.5 meters from the house.
Okay, thank you.
Any other questions, panel members? Okay. All right, could we have the next speaker, please?
Maria Galati, you've been unmuted.
Hi, Miss Galati. Could we just have your name and address for the record, please?
Yes, hi. My name is Maria Galati. I'm representing my mother and my father who live at 295 Rushton Road.
Okay.
They are on the other side, so they are in Mr. Mehavich's backyard.
Thank you very much. Your 5 minutes starts now. Go ahead, please.
So to start, I'd like to say, my parents have always had a very amicable relationship with Mr. Mehavich. They've both been there for a very long period of time. And this complaint or our complaint, our concerns, their concerns come from the fact that they feel a little bit disrespected by what's been happening. And especially so in terms of looking at process and knowing his position within City Council. So we'd like to address not only the garden suite, but also the structures that he has put up, that he and his family, I guess, have erected without respecting the permit process. So just going through very quickly, at a high level, nothing respects height limits. We have a wall that goes across the backyard that we've tried to communicate to him is not respecting protocol or privacy or shadow lines, anything like this. So I'd like to go through one by one, and I think that's the fastest way. He has an accessory structure that was built, or a shed that was built way back. That structure, we still don't have the dimensions for. We've asked several times. We can see by eye that it is not within the code, but we don't have the exact measurements. And it is higher. We believe it's taller than it should be and larger than it should be. And we don't agree that it's been built. He's built a chicken coop in the backyard. Mr. Mehavich was involved with the urban hen program since 2011. When it was originally implemented, there were guidelines established that were very clear. And those guidelines said that chicken coops would be no more than 2 meters, 6 feet, 6 inches high, and a maximum of 9.2 square meters. The chicken coop is much larger than that.
I'm just going to have you pause for a minute. Perhaps staff can scroll up to show the photos.
Yeah, I think that the best way to do this is maybe just to take a look. I'll walk you through what I've written a lot.
Okay.
Take a look at the
Go
final.
ahead, please. I didn't mean to interrupt. I thought you were referring
No,
to-
that's actually a very good idea. I respect that. So to the right. So the first structure that we spoke about was in the southwest corner, which is the right of picture. The picture to the right. That shed is larger than it should be. We've asked several times, without going onto the property for the dimensions, but we can see it's larger and taller than it should be. The setbacks are not appropriate. And we still to this day don't have the right measurements, but it was built without a permit process. The chicken coop is the structure that you see to the far left. Under the guidance of the City Hen program, it should have been built much smaller. You can see that it was built much larger. And so our issues with that are you know, within the variances requested, the request is that for support of an agricultural structure in the city. That, as I understand, is not within the bylaws today, and we don't support that. You know, I have a picture within, I forget which newspaper, the Sun or the Globe and Mail. You know, like, it's nice to have hens and it's nice to have this type of thing in your backyard, but they have come into our backyard, and I do have a picture where my mother is actually handing one back over to him. We like to enjoy our property, or they as a family as well, and we don't want to go back and forth on this issue. Also, again, it's larger than it should be. It creates like, these three structures create a wall across the backyard of our family home. So we'd like to understand, like, if it's going to be accepted, is it going to be accepted as an agricultural structure? We don't agree with that. It is outside of the dimensions that were originally proposed under the program. If it's going to be seen as a hen structure, then it should be reduced. If not, how many sheds should he be allowed in the backyard, falling right across our backyard? And then we're starting to look at, these are three structures that are being erected. The third that I'm going to speak about is that chimney, faux chimney that's gone up. He also wants to build a garden suite that's much taller, you know, as the previous neighbor was saying, much taller than we'd like, and that is permitted under existing guidelines. It will create shadow lines. It takes away privacy. There's many issues, and we just want to understand how the density will look from our own backyard. Like, where's the green space? As we talk about, the next thing I'd like to talk about, sorry, I'm moving fairly quickly because I know I have 5 minutes, is the faux chimney. We had gone to the city.
Sorry, Maria, you've hit your 5-minute mark.
Yeah, so can I just say very quickly, the faux chimney, because I was cut off as we went into the picture, the faux chimney is really, I was told, or we were told, that it was erected to support an at-risk species. You know, that's not something that flies in the city, and for Mr. Mihevich to define it as an at-risk species, it's not up to him, it's up to the city, and we don't understand why that kind of structure should exist between our backyards.
Okay, so that's your 5 minutes with even with my interruption.
Sorry, rushed that.
I gave you credit for that. So, panel members, do you have any questions of this speaker? Okay, seeing none, could we have our next speaker, please, staff?
Shannon Carey, you've been unmuted.
Can you hear me?
Good afternoon.
Hi, you can hear me, right?
Yes. Is this Shannon?
Yeah, I'm Shannon Carey. And I live at 9B.
Just have your name and address for the record, please.
Yeah, Shannon Carey, K-A-R-I. I live at 9B HUMEWOOD, across the street from the applicants.
You have 5 minutes.
Things I just want to correct,
Go ahead.
on the site plan, it says the existing house is a 2-story dwelling. It's 2.5. It's not just 2, so that's inaccurate. My opposition, well, first, HUMEWOOD is a very busy street. This stretch of HUMEWOOD is two-way street, one of the only ones in the neighborhood, but there's no parking permitted on this part of HUMEWOOD, so this will cause significant disruption during the construction of if it were approved for a 2-story garden suite. And I want to, and also there's school, you know, it's be traffic hazard because they don't enforce the parking when there's contractors. There's children busy during lunch hour coming back from school into St. Clair. So that's one problem. My main thing as well in terms of opposition, echoing Ms. Galati, is that the applicants, and specifically Mr. Mihevich, seems to have a cavalier approach to following rules that the rest of us have to follow. And he, as a former counselor, he shouldn't be held to a higher standard, but he has to be held to some standard. He has to follow the rules. And nowhere in the application or in Mr. Laszlo's submissions did I hear why they should be granted the variances. And for example, like he says, well, there's 3 we didn't have the benefit of because he didn't apply. Like, Mr. Mihevich was the front man for the chicken coop program. And, you know, how could he not apply for a permit? And now they're saying, well, our faux chimney nest is just a little higher than what's allowed, except they built it without approval in the first place. So we're setting a dangerous precedent here if there are no rules that have to be followed for certain individuals. As well, in terms of the Garden Suite program, if you look at the City of Toronto's outline and summary, they're very clear that they should be that they're one story, they're not huge structures. Yes, the bylaw says if it's 7.5 meters from the residential building, they could be up to 6 meters. But this isn't. It's 5 meters. This isn't ambiguous. So what you have here is a serial rule breaker saying, can I not follow several more rules? And I don't know what the purpose of I haven't heard about anything in terms of the Planning Act, the purpose of what is this for? Is it for family? Is it for, if it's for affordable housing? I don't know. I know that the Garden Suite program has a $50,000 grant. It calls it forgivable loan if you do affordable housing, but not affordable housing. If you charge them more than the average rent that the city says is that total in that year. And on the parking pad, he said, well, they're going to remove the garage, so they need approval. Well, there's a car parked right now in the parking pad that he doesn't have approval for. So what you have is somebody who knows the rules, doesn't follow them, wants another exemption to them, and then, as you've heard from the neighbors, wants to build a very large structure that I do not think is in keeping with it's not permitted because it's not 7.5 meters back. It's also not in with the theme. A garden suite, even think of the word suite. That doesn't mean a big 2-story structure. And that's all I have to say. Thank you.
Thank you, sir. Any questions, panel members? Okay. Seeing none, we'll go back to Mr. Laszlo. Would you please respond to the issues that have been raised by the speakers?
Yes, I guess one of the main sort of themes was this height, and the previous speaker did mention it, and I just want to reiterate it again. If we were if we were 7.5 meters away from the rear of the existing dwelling, we would, as of right, be allowed to build at a 6 meter height. So my kind of point being, if we were to take off the front 6.5 feet off of this proposed garden suite, we would not need a height variance anymore. Okay, and in my opinion, the impact on the neighbor directly behind and both neighbors would be the same if we were to, just my opinion, if we were to take the front 2 meters off of this dwelling and build at a 6 meter height. As far as sort of the number of existing, so we did a proper zoning review, and everything has been documented. All the sheds and everything at the back of the property all conform to the height. They're typically at 11 feet high, where we're permitted to be up to 14 feet high. So we don't go over any of the maximum sort of height requirements, except for the chimney that, yes, is slightly over a foot higher than what's permitted. As far as the sort of number, again, we did a zoning review. There are no variances associated with the number of accessory structures or number of structures, period, on the property. So we conform in that respect. And we are just trying to legalize everything. That's sort of why we're before the committee today. In addition to getting to hopefully getting approval for the proposed garden suite. Thank you.
Thank you. Any questions, panel members?
Yes.
Yes, Ms. Chan?
Yes, my question is, can you tell me the purpose of that chimney?
Okay, so the chimney is hollow inside and it attracts different species of birds and they form their nests. They nest within that chimney. So it's not it's referred to as a chimney. It's like a hollow structure where birds nest within.
Oh, okay. Thank you. Yeah, I see. And
Chair?
you said that it's existing. The other question is, you have quite a few structures in the yard. Are these all built as described by all your drawings? Is exactly what is described in the drawings, or you're going to make modifications?
Absolutely not. They are staying exactly as is, period.
Okay, thank you.
Mr.
Chair?
Clay?
Thanks. So I want to go back to make sure we understand the way that the current permissions exist. You had mentioned, I mean, the chicken and hen, it was a pilot project. I get that. So some areas of the city were allowed to proceed with that. But you said, I thought I heard you say that the permissions currently don't allow for this in your area, but you're anticipating that council will deal with that within a year. Is that what I heard properly?
Yes, that is what I have been told in preparation for this hearing.
So, but you're presupposing then what council may or may not decide on. Is that correct?
Correct. If I may add, if it is not passed and it's not, incorporated into any bylaws within any amount of time, that structure will or can always be considered a shed, just an additional shed on the property, which is permitted.
Both structures?
Yes.
So the variance you're seeking is primarily to consider it an agricultural use rather than a regular shed.
Yes, but that the structure, it would be permitted to remain just as a garden shed if that variance is not granted, or the bylaws never change and catch up to the whole chicken coop idea.
And with the exception of the setbacks, height and coverage, you're within the provisions that would allow for ancillary buildings.
Oh, yes.
Okay, thanks.
Any other questions, panel members? Mr. Reid?
Thanks, John. Yes, to the applicant, just a question about the garden suite. I understand the variances being requested and why they're being requested, but did you look at siting it differently? There is a lot of space in that backyard, and I'm wondering if you wanted the 2 stories, why you didn't just push it back or over to get a site that would allow that without the number of variances.
Well, again, we wanted to stay out of the TPZ, the tree protection zone, for that tree as much as possible. And we kind of looked at this as, we are 2 meters further back than the existing garage. So we are kind of bettering the situation and bettering the amount of space between, the existing garage and the house.
All right, thanks.
So I have a question. So from the plans, the proposal is to have a basement and 2 stories. Under the garden suites provisions, my understanding is if you can have a height of 4 meters if the distance from the main house is between 5 meters and 7 meters. Why not have a garden suite with the basement and 1 story? Why are you seeking a permission that is only permissible with a distance of 7.5 meters?
We figured that the only one impacted by, as far as I can see it, really the only one impacted by that reduced setback, between the dwelling and the proposed garden suite is really the owner of the property, the current owner of the property. So we figured
on what basis do you feel that that request is minor?
Minor in that
and within the general intent and purpose.
Well, again, I keep going back to relating it to the existing garage that's there. And we are 6.5 feet further back than where the front of the existing garage is. So that's only making things better as far as a buffer between the proposed garden suite and the existing house. Again,
Okay.
I just feel that we're bettering the situation.
Okay, thank you very much.
Thank you.
Any other? So we'll take this into committee. Any discussion or motion? Yim?
Oh, I can start with discussion. I feel that this is, if they wanted to build a garden suite, I think the site is quite large, as Peter mentioned. I think they can actually build one, comply to the garden suite bylaws. And I feel uncomfortable to argue that a 4-meter high building is exactly like a 6-meter. I don't agree with that. And I think that the garden suite, I'm sorry, the garden suite bylaws only just passed, and I really think that they should have look at those and build a more acceptable building. I cannot support this project also because it's already built. The neighbors have nothing to no say to it then, and after this they still cannot appeal if it's approved, and I can't support this.
Okay, thank you. Anyone else? Peter?
Thanks. I agree with Yim. I think largely because of how recent the garden suite bylaw is. This is not within the purpose or intent of it. I think it's quite explicit, particularly because there are solutions on this lot to have a compliant garden suite. And yes, this does go further back than the existing garage, but it's not. I still think it's a meaningful amount that is over and above what's permitted. I'm less concerned about the shed and the chimney and the agricultural use, but you know, as the neighbor across the road said, I do think that elected officials who have a deep understanding of these processes really should be expected to follow them more closely.
Thanks. Larry?
Yeah, I'll just weigh in. I agree. With both my colleagues. You know, garden suites, sometimes they have to be, in order to get them in, they have to be shoehorned into a certain configuration. But this is a large, deep rear yard that has, as Peter pointed out, there are other options available to the homeowner to build it that would perhaps not be as close to the neighboring property. And, you know, if you move it 7.5 meters back, you can quite easily build what you're proposing as of right. So it just seems to me that there are other opportunities that would meet the homeowner's objectives without needing this kind of variance. I similarly am not as fussed about the rear yard ancillary structures because basically that's what they are. It's more about the use as opposed to the actual structure. So I'm fine with that.
Okay. I'll just put my 2 cents in. I agree with the comments that my colleagues have made. I think that the proposed location of the garden suite and the height, I can't support. I don't have a concern with respect to the ancillary structures. I do have a little bit of a concern with respect to the variance on the use, but wonder whether or not if the committee were to authorize those variances, whether or not there would be any utility to putting in a condition that the variances with respect to agricultural use only be permitted for a certain amount of time to allow, as the applicant's agent has said, their expectation that that use is going to become a permitted use. So that's just a thought on that I'd certainly appreciate hearing what my colleagues thought on that.
Yeah, personally, I would agree with that. I right now it's a non-conforming use, right? So I think having a provision in that sunsets that use in the event that city council doesn't approve it would make some sense. I suspect that's what happened anyways, because it would then become an illegal use. But I'm fine with a condition to that effect. I'm something along that lines.
Okay, so if there's nothing else, can I get a motion from someone?
Yes,
Yim?
I have a different motion. I just have a motion to refuse the application.
In total? All the variances?
Yes, because the shed and all, it's got, they're not applying for any variances for the,
Yes, they are.
they are?
Yeah. Side yard setback, the ancillary building height, and the agricultural use.
So I'm nervous about approving a non-conforming use now, even with conditions. I do not think I can approve, agree
So
with
your-
number 8.
So your motion is to refuse the application in its entirety. Okay. Is there a seconder to that? Okay, I don't see a seconder. Then do I have another motion? Mr. Reed?
Sure. I think I agree that there isn't a harm in approving part of it. So I would move to refuse. This is going to take a sec, sorry. But to refuse variances 1, 2, 3, and 5. And approve the remainder of the variances. And variance 8 be approved, maybe say for a condition for a period of 2 years, to allow, if the city does pass this on a more substantive level, then that should give them sufficient. And then also subject to urban forestry condition number 2.
Okay. Do I have a seconder for that motion?
Just before I second it, Peter, can just going back to number 5. I don't think we really talked a lot about parking. So can we just unpack that a little bit?
I think the parking variance was being requested because the parking space in the existing garage was being removed, and so then it was parking to be supplied on the site. It would have to be in the front. So I think the fact that we're denying the garden suite will mean that the garage remains and the parking space remains.
Right, and if the applicant chose to come back at a future date, relocating the garden suite, then they can deal with the parking at that time as well.
That would be my assumption, yeah.
Okay. I'll second that motion,
Sorry,
Chair.
through you, Madam Chair, could we just go through one more time what variances are being refused and what are being approved?
Sure.
For sure. So refuse, yeah. Joanne, if you can double check what I'm saying, just to make sure.
So number 1 refused.
Yeah.
Number 2 refused. Number 3 refused. Number 4 refused. So that's garden suite. Number 5 refused. Number 6 approved. Number 7 approved. Number 8 approved with a condition that it be limited to 2 years. And number 9 approved. Did I get that right, Peter?
You did. Sorry, I had missed variance 4 previously. So yes, that's right. Thanks.
Okay, and Larry, do you still second that motion?
I do.
Okay, so we have a motion as stated to refuse variance 1, 2, 3, 4, and 5, approve 6, 7, and 9, and variance 8, approve it with a condition that approval be for 2 years. And that's moved by Mr. Reed, seconded by Mr. Clay. All in favor?
There's a better motion than mine. I agree.
Okay, and that motion carries. Okay, we move on to item number 10, and I believe
Yes, through you, Madam Chair,
Bruce is
we
coming
will
back?
get Mr. Mullock back in the room.
Okay, thank you.
Thank you, Ms. Hayes. We move on now to item number 10. (1169) Davenport Road. On this item, the panel has before it the following materials. Those submitted with the application. There is a cover letter from the agent received January the 4th, and there is opposition correspondence from the following: 102 Somerset, 76 Somerset, Alberto Tomei, no address, 1157 Davenport, 100 Somerset, the Davenport Neighborhood Association, from 96 Somerset, from 98 Somerset, and from 30 Rains Avenue. So we shall ask the agent please to join us.
Hello, everyone. Hello, Mr. Chair and members of the committee.
Good afternoon to you. Okay, you have 5 minutes to present your application to the panel. Go ahead, please.
Yeah, my name is Hassan Rostami, and I'm the architect and agent on file. If you can you please present us with the first letter, the cover letter that I've sent to the city? Thank you. So we are seeking approval for 5 minor variances, which the first 2 and the second 2 are very similar, so I just bundled them together. The existing building is actually a 1-story retail. The front is just a retail, plus a second story that is residential, and the back of the retail is residential, and a basement that is for residential as well. So the whole thing is 4 units. 3 of those are residential uses, and the retail one was used as a live workspace because I've actually visited it at the time. Now, if you go to the cover letter, the first and the second variances is asking for the extra FSI. The allowed FSI.
Hello, you've reached 647 now.
Sorry?
I'm sorry, that was, carry on with your presentation, please. We're not sure.
Yeah, I'm so sorry. So, so the first and the second one is regarding the FSI. The allowed FSI in this zone is 1.5 CR. C stands for commercial allowable 1, and the R is 1.5, which means that we are allowed actually to have the whole structure as residential. The allowed uses are actually apartment building and townhouses, as well as a mixed use. And if we would have gone with townhouses, the basement would not count toward the FSI, bringing us down to 1.67 rather than the 2.3 that is shown here. In fact, the existing building with the residential uses has an FSI of 1.74, which is higher, 0.24 higher than the allowed 1.5. There are some other examples in the neighborhood that has been approved. I'm not going to go through the whole list. If you go to, sorry, can you just carry on with the, yeah. Can you go to the next page? Those are the existing building. Those are not proposed. You can see in blue, yellow, sorry, can you, yeah, thank you. You can see in the ones that are shown in blue, yellow, and green are residential units, the existing one. And the one in red is actually the dry cleaner. And the back of that dry cleaner, at the time I've actually visited it, it was being used as a a living space for the owner. The owners had that dry cleaner for a while, and the business was not that strong, so they decided to actually sell the property, and they wanted to retire, and that's why Mr. Katz, my client, actually bought it and tried to actually make a better rental affordable units in that area. If you go right here, I just wanted to talk about the third and the fourth variance, which talks about the mixed use and the elimination of the retail. And that's the reason why we kept it. If we look at the definition of the apartment buildings, the apartment buildings can be starting from 5 or more units. I'm sorry, in this letter I'm saying 6, but that's a mistake. It's actually 5 or more units. So in our proposal, if we would have made the back unit just 2 studios rather than a 2-bedroom, that would have eliminated these 2 variances regarding the uses. So the fourplex that is, here could have been converted to an apartment building very easily, but my client was in favor of there are enough condos and 1-bedrooms and studios in the area, and he wanted to bring more families with kids and a secondary bathroom, and that's why we went with that design. There has been a lot of back and forth with Adam Khan, the person on file, the planning department, to actually get to this proposal that is in front of you. If you go to the next page, can you please go to the next page? Thank you. So you can see I've actually made a panoramic view of the north and the south of the Davenport Road in that vicinity.
Applicant, I'll ask you to make your final comment now, please.
Yes. So the last one is regarding the courtyard. Can you go to the next page? The courtyard and the main wall. The distance between the main walls in the bylaw is allowed to be 5.5 meters if in front of that window there is only a blank wall. And that's what we have done here, to actually divide it into 2 courtyards rather than 1. And that's why that's regarding the last one.
Thank you very, very much. Okay.
Okay.
Panel members, questions at this stage? We have 3 or 4 speakers standing by. Okay, let's go to the speakers then. Moderator, first speaker, please.
George Svarnus, you've been unmuted.
Good afternoon.
Good afternoon. How are you? Good afternoon, Chairman and committee members.
You have 5 minutes to address the committee. Go ahead.
Okay, so my name is George Varnes. I'm a representative of my parents who live at 102 Somerset. I'm just one of 2. So I am completely opposed to this application because it's not a minor variance. Our property is directly affected by this variance because it's adjacent to 1169. But my brother Steve, who's also a representative for my parents, has submitted photos, which you will get a better visual of what how it directly affects us. It completely, significantly reduces our natural sunlight, the very little natural sunlight that we have in the backyard as of right now. So it'll, I mean, whatever green space or vegetation life that we have there currently will just sort of disappear. It's very intrusive, the structure, and sort of if this project gets approved, it sort of will create an umbrella-like effect in our backyard. But again, my brother Steve will better describe sort of the pictures that he brought forward, he submitted. So yeah, thank you.
It's this guy right here. Invite and remind panelists.
Okay. Is your brother going to speak?
Yes, he will, yes. His name is Steven Svarnes.
Okay, he can join us now.
Steven,
Hello.
you've been unmuted.
Hi, this is Steve. Have you been, am I good now? Can you hear me?
Yes, we do, Steve. Go ahead.
Okay. All right, Stevens Varnas, 76 Somerset Avenue, also a member of the family on 102 Somerset. If we can begin, staff, on page 2, please. I think I want to just highlight here pictures of the second and third floor addition and expansion of 1176 Davenport proposed, which significantly, if you look at my green area, that's the area of the courtyard that is proposed for a courtyard. So the design of the courtyard and patio in this space does not really support airspace or sunlight preservation, especially as a result of the adjacent building of the third floor of 1173 Davenport. So you could just see by the mere structure that I've highlighted in black here what this does to the backyard space, impacting not just 102 Somerset, but 7 properties adjacent to where this build is going to be situated. It changes the complete nature of the backyard, and the protrusions have a major impact on this design, and is definitely, I mean, pretty obvious out of character. If we can go to page 2, staff, page 3, sorry, next page. I wanted to just highlight here, if you're looking beyond the distance of the courtyard, you can see 1173 Davenport, even with the attempted preservation of a courtyard and airspace, this really doesn't create anything visual beyond this courtyard that Mr. Rostami is proposing in the design. There's an adjacent wall right next to that structure. If you go to the next page, I've also highlighted the front view of the property of 1173 Davenport in respect to 1169, and that's the courtyard that we're overlooking and just looking at an adjacent structure. Next page, please, for page 5. I want to highlight here, this clearly, this second floor and third floor addition pretty much eliminates 80% of our sunlight in the backyard, and the red arrows indicate greater than 80% reduction. Sorry, the red arrows indicate and represent vegetation areas that we rely on heavily in the summer months, and more than 7 properties are going to be impacted by this structure. If you can go on the next page, page 6 and 7, just highlights our existing view, and you can see what impact this will have. And you can go to the next page as well, just a secondary view showing it directly westward. Next page, page 8. Clearly, I want to highlight again the shadowing of surrounding properties that this will create. For example, blocking.
I'll ask you now for your final comment, please.
Sure. Blocking of afternoon sun significantly reduces sunlight, contributing to, I guess, symptoms of seasonal affective disorder. And lastly, just we're boxed into this. You could see on the north wall at some point there's a property 106 Somerset was severanced and to build 1167 Davenport. So we're completely boxed in on the north and now looking west with this proposed structure. I think that's the main points I wanted to highlight in the time that I've been allowed. Thank you.
Thank you very much. Are there any questions, panel, for the speaker? Okay, thank you. Next speaker, please.
Through you, Mr. Chair, I've tried contacting the next 2 speakers, and they have not responded to phone calls.
Okay, thank you, moderator. Okay. All right, then let's go back to the agent, who will have an opportunity to speak in rebuttal to the submissions made.
Hi, everyone. I want to thank you, the Savarnas brothers. We have, Mr. Katz actually contacted everybody that sent an objection letter, but unfortunately did not get any response from any of them. That was a disappointment because we wanted to actually discuss and see what we can do to actually help them. We looked at this project very carefully and we tried to minimize the impact. If you look at the, can you bring my second cover letter that I sent in response to the objection in lieu of the actual conversation with the neighbors? It has been uploaded to the portal. I saw it this morning.
This morning?
Yes, last night probably. I checked it this morning and it was uploaded. Thank you. That is correct. Thank you. So I think that, most of the other objecting letters regarding the retail, that's not a big issue. Let's just, move forward with the ones that is actually matter. And that's the three properties right adjacent to the east side of this property, which would be affected with the shadows. Can we go to the next page? Forego this, sorry, next page. So just wanted to mention that we are sitting at, there is no height variance that we are asking for. We are sitting at 11.48 meters rather than the allowed 12-meter height. We are not asking for any setback variances. We are fine with the planning. The planning has no objection. And if you look closely, what I've done here is that on the top, I've actually drew what is allowed by law as of now. With that proposal, we do not need to actually come to the committee for any approval. And you can see there is a huge shadow that is casting to that backyard. So that's the main reason that we started the courtyard from the very beginning, was to actually allow them to have more sunlight and have more access to the sky. If you go to the next page, the top is as per bylaw, as of right. And then the bottom is our proposal. So what we are doing, you can see the shadow casted on the back property is less, and also to all the backyards of these properties. We are in the same CR zone, meaning that all these properties on the east side of us, I know that they're right now single family houses, but they can actually are in CR and they're benefiting from the same zone. And that's one of the reasons that we felt appropriate to actually add more units there and make a use of what is allowed in bylaw. Can you go to the next page? Just to help everybody to understand why we have done that courtyard, I've actually made these as of right versus what we are proposing here, so that you can see the courtyard is actually helping quite a bit. In addition to that, when we got this with this objection letters, and my client actually contacted me and told me, what is it that we can do to help these particular neighbors to the east of us? And what we have done is that we actually lowered our structure by an extra 2 feet. So right now we are sitting at 10.9 meters height. Sorry, because there is no variances regarding that height, I could not make a remark at the beginning of our discussion, but instead of 12 meters high, which is the one that you can see at the very far back, which is 1173 Davenport Road, we are sitting at 10.9 meters, which is 1.1 meter less than allowable by law. Can you go to the next page? As you can see here, we have designed in a way that, when you're looking at it from the urban edge, it is in line with the rest of the properties. And when you're looking from the corner, and can you go to the next page, from even the other corner, you barely see the structure in the back, and the looming effect that if we would have gone with as of right is actually reduced quite a bit. I would welcome any questions or any further comments that anybody has.
Thank you very much. Okay, panel members, yes, are there any questions for the applicant? Ms. Chan, go ahead.
Yeah, just a clarification. You have sort of a courtyard on the second floor above in the middle of the building. So in that sense, I just want to know that how is it lined up with the other houses on Somerset? So what I'm trying to understand is that the courtyard actually give opening to some of these properties. So the extra height of your proposal will only affect 104 or more properties.
So it is going to be I would argue on their behalf that it would affect 100, 102, and 104. But we are not asking for any extra height. And we are willing to work with any of these owners if they have any privacy issues. But there's a balance between the privacy issue versus the shadow effect. So that's why
I understand that. But what I'm trying to say is that I try to sort of identify how much the impact. I mean, the your open courtyard. I think that helps to mitigate some of the effect. And I'm thinking that maybe not all of them are affected equally.
Can you go back to the floor plan? I understand, Ms. Chen. Can you go back to the one that has the plans with the shadows, please? Thank you. This one, yeah. If you look at the way that the top and the bottom, I actually did a full shadow study, but for the sake of shortening the argument, I just prepared these two images at the same exact time in SketchUp and the same sunshine. So if you look at the properties on the right hand side, there's a line V2 map. For whatever reason, it doesn't show the full extent of their backyard. It shows exactly where that line ends, whereas the reality is that those backyards extends all the way to our property. If you look at the top portion of that of our building versus what is as of right and that courtyard, you can see that there is a benefit to our proposal versus the as of right. And when the sun moves, I wish that I would have shown you more of that shadow study. When the sun moves, actually the other guys get a better light and view to the sky too.
Yeah, that's what I want to find out, and I think maybe your neighbors like to know that too.
Yeah.
Mr. Clay, you had a question.
I did, Chair, but it's been answered. Thank you.
Thank you. Okay. Any final questions for the applicant panel? No. Hearing none, let's take the application into committee for a motion. Any comments prior to a motion? Ms. Chan?
I can start with my comment. I think that overall, if you look at the design of the building, I think it's very well planned, and given it's on the main street, Davenport, and I think that it actually a very desirable area to live and to have larger units. And as I mentioned, they actually have broken up the building so that the interior has some opening there, and I do not think that it will affect all the backyards in terms of shadow, and also the fact that they are on the west, so and then the other properties still have a lot of sunshine in the east and the south. I'm not too concerned with that. I think I can support this proposal.
Okay, thank you. Anyone ready with the motion? Mr. Reed? Or comment?
Yeah, I just wanted to add one more thing. I do think that this is a well-designed proposal and a really interesting way to add density to a major street. I do regret a bit that the commercial space is being removed from the first floor. But I think that the applicant's description that this is very close to an apartment building in terms of definition, that gave me a bit of comfort, but I'm slightly sad to see that go. But regardless, I still think it's a good application, and I would move approval with no conditions.
Thank you.
Peter, would you be okay with tying it to plans? And the reason is for the privacy screening for the courtyard and also the height, because it's less than as of right, and I think it might be good just to bolt that down.
Yeah, that's a great idea. So maybe we tie it to elevations or just all plans. Is that safer? Maybe, Larry?
I do all plans, Peter.
Okay, to plans.
Okay. Is there a second for that motion? Mr. Chen, you're seconding? Yeah, okay. Moved and seconded. It is moved and seconded to approve, subject to being tied to all plans. All those in favor, please, show of hands. And that vote is unanimous to carry the motion, and the application is so approved. Thank you. Number 6, Roseheath Avenue is number 11. And we'll ask the agent to join us, please.
name's Mackenzie. Hello?
Hello.
Hi, sorry, you can hear me?
Yes, could you state your name, please?
Hi, my name's Mackenzie Rentz, and Dana Evans is here with me.
Okay.
We're from 209 Design, and we're representing the homeowners, Scott and
good.
Michelle, for 6 Roseheath Ave.
Very good. Okay, then just stand by a second while I check with my colleagues. Panel members, anyone wishing a presentation on this? No one is. Any questions to put right to the agent? I'm not hearing any questions. So in that case, I wonder, panel, is there anyone ready with a motion on the application? Ms. Hayes, go ahead.
Thank you, Mr. Chair. I think that what's being proposed here is certainly reasonable. I think they've, they're really putting a topper on an existing one-story addition. I think the minimal impact. I think the FSI variance is not out of context with other built forms in the neighborhood, and I would move a motion to approve the application with no conditions.
Thank you very much. Does that have a second? It is seconded, Mr. Clay. Moved and seconded to approve without condition. Those in favor, please show hands. The motion is carried, unanimous vote. The application is approved. Number 12 is 227 Pape Avenue. On this application we have before us submitted materials. Cover letter from the applicant, 12 September. A previous Committee of Adjustment decision from 2002. Presentation materials from the agent, January the 9th. There's one piece of correspondence in interest or concern from Edith Karwecki, who provides no address. Okay. Let's have the agent join us then, please, for number 12.
Good afternoon, Mr. Chair and members of the committee. My name is David Sujaki. I'm the applicant, co-owner, and resident of 227 Pape Avenue, as well as a co-founder of Sujaki Planning. There was a, Mr. Chair, there was a short presentation that I provided as well. I'm wondering if it's possible to pull that up, if you'd like a presentation.
Thank you, David. I'm just going to check with panel members if we need one. Panel members, do we need a presentation here? No. Does anyone have a question for David, who's the owner and the agent? Mr. Clay, go ahead.
Just a quick question. The individual wrote in was concerned about parking, and this being now an office space. What's your plan for accommodating employees' parking?
So we are not looking for any on-street permit parking. I know that was the concern of the neighboring resident. Along Pape, you're only permitted to park for 1 hour during regular business hours, of which we would be open. We would only be looking to have, say, 4 or 5 team members in the office at one time. We would be looking to use public transit, cycling to work. Many of the members of the team live within the area. And meetings in terms of client meetings, those would be, we haven't had one client meeting in person in an office since the pandemic. So we tend to always go to clients' offices for those meetings. So we would not be looking for any permit parking. We would discourage driving to the site. We would be open to, to other means of procuring parking if that was deemed necessary.
Okay, thank you. I'm just curious about this. The building looks as if it was a storefront historically. How long has it been residential?
It's been residential for quite a few years. In the past, it has been a bakery. It has been a canoe shop. The neighboring property more recently, the neighboring property just to the south, so 3 properties in that more recently has been a convenience store. It was Mary's Convenience. But as far as I know, for the past couple of decades or so, it's been residential.
Very good. Okay, panel members, any other questions, or is anyone ready with a motion? Mr. Clay, go ahead, please.
Sure, I think this is quite straightforward and quite reasonable given the location and the proposed use. I'd like to move approval with no conditions.
Thank you. That is seconded by Ms. Hayes. Moved and seconded to approve. Those in favor, please show hands. And that is carried, that motion. Unanimously, the application is approved. Number 13.
Through you, Mr. Chair, just before we start the next item, just as a programming note, we're still hearing items for the morning session. If you've just tuned in for the afternoon session, we're going to go through the morning session, and we envision starting the afternoon session at 4 p.m. or shortly thereafter. So again, if you are joining us and also tuning in for the afternoon session, we will begin at 4 p.m.
Thank you, moderator. Very, very important. And just for those who may be tuning in for the afternoon session, the panel has been working away here diligently since 9:30 this morning, but we are still working on the morning agenda, and that's the reason for the delay in beginning the afternoon agenda. Okay, number 13. 749 St. Claren's Ave. Before us are submitted materials. 3 photographs of trees on the property. Shadow study and renderings from the agent. And there are 8 form letters in support from owners and occupants of 694, 700, 745, 747, 751, and 755 St. Claren's, plus 224 Emerson Ave. Okay, agent.
Hello, can you hear me?
Hear you clearly, yes. State your name, please.
My name is Eric Martin from Picnic Design. I'm the agent for the owners at 749 St. Claren's Avenue.
Thank you so much. Okay, panel members, anyone like a presentation on this application? Does anyone have questions for the agent? I'm not hearing any on either account. Is anyone ready with a motion on this application? Mr. Reed, go ahead.
Thanks, Chair. Yeah, I want to thank the applicant for the materials provided. They were very helpful in terms of illustrating the proposed built form. I think the variances are minor, and this really does fit in with the pattern on the street. This isn't going excessively deep, and there's nice modulation in the massing that lessens any negative impacts that could come from this addition. So I'm happy to move approval with no conditions.
Thank you so much. That is seconded by Ms. Chan. It is moved and seconded to approve the application. Those in favor, please. Show of hands. That vote is unanimous to carry the motion, and the application is approved. Thank you. Number 14, 712 Vaughan Road. Panel is considering submitted materials with the application. There is a submission of presentation materials from the agent dated 28th December, and there is one piece of correspondence in opposition from 710 Vaughan Road, which would appear to be next door. Let's go to the agent, please.
Hello, my name is Ozren Stambuk. I'm the agent for this application, and I reside at 15 Moreland Road.
Good afternoon to you. Okay, I'm going to check with my colleagues to see anyone like a presentation here. Any questions for the agent, panel members? Ms. Chan, go ahead.
Yeah, I just have a very quick question on the balconies, the second and the third floor balconies. Have you talked to the neighbors? Is there any kind of privacy issues there?
There hasn't been any privacy issues expressed by the neighbors, and as you can see with the opposition letters, it was mostly relating to other subjects. So we don't have any concerns of privacy so far.
Okay, thank you, because that's the only thing that I can see. It might be a problem. Thank you.
Okay, I'll put the question to you. The neighbor at 710 did write to the committee and submitted photographs and so on. Have you reviewed that material?
Yes, thank you, Mr. Chair. Yes, I have reviewed that material, and the supporting material I submitted was in response to that letter. So there's a few kind of misunderstandings in the letter about the proposal, and the common questions about rainwater runoff and as such. But the biggest issue was, as you can see on the screen in front of you right now, is the blocking of these two windows by the proposed 3-story addition at the back. Well, actually 2-story. And I submitted also, that was on the 28th of December, I submitted a response showing those photos and explaining that those windows would be blocked in the same way as of right, if the application was, let's say, as of right, and we stepped in the proposed wall of the addition. And the basic reasoning for us that we do not want to step in that wall because it would not have an effect on the shadowing of those windows, but mostly it would have a big effect on the budget if we weren't building on the existing wall.
Thank you. Okay. Further questions, Mr. Reed? Go ahead.
Thanks, Chair. Just one, and it's a follow-up to Yim's question, but to the applicant, would you be opposed to having screening on the west side of the second and third balconies, just because the overlook to the west property is pretty direct?
I actually haven't spoken to the owner about that concern. So if that is the only way committee would consider approval, then certainly it's not an issue to include privacy screening, because we have no intention of overlooking other properties. So if that's a concern for this property in the backyard, I would certainly be supportive of that condition.
Thank you.
Thanks.
Okay. Is anyone prepared to go forward with a motion? Ms. Chan, go ahead.
Well, I can do this one. Yeah, that's my main concern. But then since he said that there are no concern raised, but on the other hand, maybe it's not being noticed yet. So I think it's a good idea to put the privacy screen on the west side of. Peter, you think should be the second and the third, both balconies?
I think so.
Okay, both balconies. And I move for approval with that condition. Privacy screening is 1.5 meter high from the deck. Yeah.
Okay. So your motion is to approve with privacy screening 1.5 meters.
On the west side of both second and third floor rear balconies. Yeah.
Okay. Very good. Is there a second? It is seconded. Ms. Hayes. Moved and seconded to so approve. Those in favor, please show hands. And that motion is unanimous to carry the motion and to so approve the application. Application number 15 has been withdrawn and dealt with by the panel at the beginning of the hearing. That takes us on to number 16. Now, at this stage, we are at 2 p.m. and panel has been going now for 4.5 hours. I'm going to, at this point, recess the panel for a bite to eat and time for lunch, and then we'll return to finish off the morning applications, which still have a way to go. So at this time, we can take Okay, we can, yes. Just a second, hang.
Sorry. When do we return? Sorry.
We're still going to determine that. Just give us 30 seconds, please.
Oh, okay.
Okay, panel. Very good suggestion here from the Deputy Secretary Treasurer. We have 4 more applications on the morning agenda. Of those, 3 are uncontested. So what we're going to do is to go through the ones that are uncontested, and at that point, we will break for lunch, take a half-hour break for lunch. So we're going to hold item number 16 until after the lunch break, and the same will be true of item number 19. There's opposition on that. We'll hold that till after the lunch break. We will deal now with numbers 17, 18, and 20. So let's go to number 17. And on 17, we'll ask the applicant, do we have the applicant with us?
Michael Scott, you've been unmuted.
Hello, thank you. Good afternoon, Michael Scott. I'm the agent for the owner.
Very good. Okay, Michael, I'm going to check with panel. Panel, anyone have questions here for Michael, or not hearing any questions? Okay, then. Is anyone ready with a motion on number 17? Ms. Hayes, go ahead.
Thank you. I think that what's proposed here in terms of extending this legal non-conforming use is not going to have any greater impact, and I would move a motion to approve it with no conditions.
Thank you. That is seconded by Mr. Reed. It is moved and seconded to approve. All in favor, please show hands. That vote's unanimous, so thank you. Number 17 is approved. Number 18, 3152 Dundas Street West.
Good afternoon.
Good afternoon. Just hang on for a moment, please. On this application, we have before us those items submitted with the application, plus some presentation materials submitted on January the 10th by the agent. Questions for the agent panel? Not hearing any. Is anyone prepared with a motion? Mr. Clay, go ahead.
Yeah, Chair, I think this one similarly is very straightforward. It was quite well thought out. It is an application to support a local business and some additional residential use. I think it's very minor and quite appropriate for the area. I move approval with no conditions.
Thank you. And that is seconded, Ms. Chan. Moved and seconded to approve. Those in favor, please show of hands. And that vote is unanimous. The motion is carried. The application is approved. We skip now to number 20. As explained, we're going to be holding number 19 for right after, well, to follow number 16 after a brief recess of 30 minutes. Number 20 is 405 Roxton Road. And on this one, we'll ask the agent to join us, please.
Good afternoon, committee members, Mr. Chair. Graham Barrett, SGL Planning and Design, agent for the owner of 405 Roxton Road.
Very good. Good afternoon. Okay, panel members, on this one, Okay, on this one, do we want a presentation? Are there questions? Question, Ms. Chan, go ahead.
No question. I have a motion. Yeah.
I do have a question for, a couple of questions for the applicant. Number one, this is a situation in which the committee is being asked to legalize an existing condition, correct?
Yes, that's correct. The porch and basement walkout in question are existing and have been since at least 2007, based on Google Street View. I'm not entirely sure of the circumstances surrounding how we've arrived here, but it's been there for, looks like at least 16 years.
At least 16 years.
Yes, if you go on Street View and use that back in time function, you can see this existing porch and basement walkout all the way back to 2007.
Okay. Other questions, panel? Is anyone ready with a motion? Ms. Chan, go ahead.
Yeah, I move for approval, and because for the landscape deficiency, and as you look at the site, is actually a great part of the soft landscaping area is city owned. So I think that the condition is not that that bad. So I move for approval with no conditions.
Thank you. Mr. Reed is seconding your motion. It is moved and seconded to approve. Those in favor, please, show of hands. And that's a unanimous vote. So number 20 is approved.
Through you, Mr. Chair, item 19, we also don't have any registered speakers for that item as well. So perhaps maybe we could deal with that at this time.
Okay.
And then take a break, only because it should be noted that for item 16, there are 6 registered speakers in opposition, so
Yes.
that item will take some time.
That makes sense, Madam Deputy Secretary Treasurer. So let's go back then, panel members. We're going to walk back one to item 19, which is now uncontested. On item 19, we have 236 Gerrard Street East. Before us are submitted materials, revised site plan floor plans from 9 January. Cover letter from the agent, Jan 4. Shadow study from the agent, January 4. Comment from Transportation Services, and 4 form letters supporting the application from 230, 232, 234, and 238 Gerrard East. Okay, agent, join us, please.
Good afternoon.
Good afternoon. State your name, please.
My name is Sean Galbraith. I'm a planner here on behalf of the application.
Thank you. Okay. Panel members, on this application, are there questions for the agent?
Chair?
Yes, go ahead.
Sean, I must admit, this one gave me a little bit of pause, and I want to chat a little bit about it. I'm not sure if I'd categorize this as being creative or sneaky. This is kind of looks to me like it's a laneway suite, but since it's got an attached walkway to the existing structure, that it doesn't qualify as a laneway, and you're considering it an addition. Have I got that right, or maybe you can convince me otherwise?
Well, the property has commercial zoning, so it's not considered a laneway suite in any event.
Okay.
Yeah, it's a mixed use zoning. It's not a residential, typical residentially zoned property. And so as a commercial property, there's additional depth and height and other considerations that are permitted that aren't permitted if this was just a typical R zone, for example.
Okay, well that's helpful to me, because my initial reaction was, boy, if this were laneway suite, permission.
I wouldn't be involved if this was a typical laneway suite. In the middle of a neighborhood, I would agree this is far too big, but because this has commercial zoning,
Okay.
And right across the street, there's a new 7-story building approved and the same zoning. So this
Yeah,
is
okay.
a little different context.
Yeah, that's helpful. I do appreciate that. And it looks like from your rendering, there's a building right next door, which is
Correct.
equally high.
Correct. Yeah, ours is a tick taller because we have the sort of rooftop enclosure for the intensive green roof, but otherwise it's pretty much the same height.
Okay, that's helpful. Thank you.
You're welcome.
Mr. Clay, would you care to make a motion?
Sure. Unless my colleagues have any other questions, they're all good.
Larry?
Yes.
Sorry, I just want to add a comment is that because of the rooftop patio that has got the dimensions on the roof plans, if we're going to approve, I think we should tie it to the roof plan. Yeah.
Sure.
Yeah, because it is much smaller than you think. They only propose a very small patio area. Yeah.
Yeah, and it is, again, it is commercial area, so I'm not as fussed about, adjacent neighbors and such. So I'm happy to move, unless my colleagues have any further comments, I'm happy to move approval of this one, subject to the condition that we tie it to the rooftop plan.
Thank you. That is seconded by Ms. Chen. It is moved and seconded to approve. All those in favor, please show hands. And that's a unanimous vote to carry the motion. That application is approved. So thank you, panel. Yes, that cleans up the morning agenda with the exception of number 16, which has quite a number of persons wishing to speak. So we'll now take a 30-minute recess until 2:51 and resume then with number 16. And having completed number 16, we'll launch immediately into the afternoon agenda. So recess now for 30 minutes. Thank you, panel.